Sir, may I help you?
Judge, good afternoon. Michael Becker on behalf of Howard Hunt on the top of page 17.
Is he Howard Hunt?
He's sitting right over there.
Is that Howard or E. Howard Hunt?
It's actually St. John Howard Hunt. Michael Becker.
Okay, this is declining
the judge.
public defender.
I spoke to the state on this. He has some early priors out of California in the 90s. He comes from
Give me a moment.
okay. Top of page 17. Just be quiet, and your family's working on the bond now, okay? Can you hear me? Can you hear me? Your family's working on the bond now. All right.
Oh, are you speaking to me,
I'm talking to you, yeah. Just be quiet.
Yeah.
And we're working on the bond, okay?
Scott Kramer?
Mr. Hunt, you're charged with distributing, delivering methamphetamines, possession with intent to sell, deliver methamphetamines, drug paraphernalia, possession. Just assume leave the bonds where they are.
I think that's fine, Your Honor. The family's working on it now. He's got a history, and they want to get him in recovery. Okay? Okay? All right, thank you. Be quiet, and you should be out soon. All right? Bye-bye.
All right, sir.
Thank you, Judge.
Go outside and have a seat. When you guys finish at the podium with the judge, go outside and have a seat so we can take you back.
Mr. Sherman, how are you?
Your Honor, I thank you very much for rolling this over from this morning.
Let me find your paperwork here.
Tommy Dobson Jr. Actually, Tommy Lane Dobson Jr. Domestic violence.
It's President of the Maine, Judge.
Okay, now, Tommy Dobson Jr. being represented by Mr. Sherman. Please allow him to speak on your behalf. You don't need to say anything. Mr. Sherman, your client's been charged with a domestic battery.
On the good side, Your Honor, he's 35 years old. He's lived in Florida his whole life. I know his mother, Tina Blaze. She is confined to a wheelchair. She's legally blind. He got a job about 9 or 10 months ago with a construction company. Admittedly, he does have a prior record. He has been to prison, but there's no reason why he should have any contact directly or indirectly with the alleged victim. His family needs him to be released. He lives in Margate. I believe his address is on the police report, 3541 Merrick Lane, number 102, in Margate, Florida. In fact, the construction company, Emerald Construction, is on there, and the fact that he has lived in Florida his whole life, 35 years, is there. The PC says that he allegedly bit her hand, pulled her hair, and as he was doing that, she was driving into the police department and actually refused any treatment at the scene.
Okay. Let me ask her, did you have any contact with this?
Yes, she is listed to be in fear and does not want any contact.
He has a significant prior record, Your Honor. 2009 strong-arm robbery, 22 and a half months state prison as a habitual offender, 06 grand theft auto, 01 battery, 98 aggravated battery on a law enforcement officer and grand theft auto with a VOP, 42 and a half months state prison, 98 grand theft auto, and resisting without violence.
Got it, okay. What does he do for work, sir?
He does construction, Your Honor. In fact, it says it on the police report. He got a job his mom said 9 months ago. The police report says 10 months ago with Emerald Construction.
I understand. So he said he grabbed a woman's shirt, pulled her hair, stated I should punch you in the effing face. She had to drive to the police department in the parking lot to get help. She provided a sworn statement. So he does have a history, prior battery, aggravated battery, strong arm robbery. Court's going to set his bond today at $6,500. The court will order that he has no contact directly or indirectly with Miss McPherson. That is Loxie McPherson. Don't call her. Don't text her. Don't email her. Stay 500 feet from her at all times. That's where she lives, works, goes to school, anywhere in between. You're not allowed to possess guns, firearms, or ammunition while you're on release. Thank you.
Your Honor, may I respectfully suggest if Your Honor would make the bond $3,500 and make a special condition of his bond that he attend the batterer's intervention or anger management. The family needs every dollar, and he really, I mean, I don't think that they own the home that his mom is living at or that he is living at, and so if you could reduce it and maybe make a special condition, attend anger management or something.
Well, let me put it this way. Regarding anger management or any of those, I've come to the conclusion, I've spoken with other judges, in this court's opinion, that putting somebody in a program where they have to pay that kind of money over that period of time crosses the line from a pretrial issue into a punishment issue where the person hasn't been found guilty yet. And I think if I put somebody in that, I'd cross that line, basically punishing him before he's found guilty. Now, I don't want to go down that road today, but I think the bond he's got has been fair. Based on his lengthy criminal history, I think I'm going to leave it where it is, all right?
And just for the record, I anticipate representing him pro bono. I got a call from his mom, who I've known the last 20 years, so I didn't want to give the court any indication that I was getting paid and asking the court to reduce bond.
No, I didn't think that, sir.
Thank you.
But I appreciate you coming in.
Thank you.
Sir, you're an attorney?
Judge. Good afternoon, sir.
What can I do for you?
I do have a matter on page 8 of Your Honor's calendar.
Okay.
My client is Chantel Robertson.
Is he Chantel Roberts, please?
Robertson, Judge.
Robertson?
Thank you.
Okay, just
Yeah,
give me a
no,
moment to
give it back.
locate the paperwork.
Yeah, I'm just trying to make sure.
Is it over there?
Her.
Do you still have
I think I gave it back to you. It was...
I got it, yeah. Yeah, Your Honor. Your Honor, here's the thing. There's no paperwork for her, but her husband and co-defendant's on the docket, Jason Robertson, and there is paperwork, the affidavit for
Let me
him.
find that. Okay, I see Jason Robertson. Anybody else connected to that?
Just these two?
Okay, so we don't have the paperwork for your client because I guess she's going to be on tomorrow's docket, maybe?
She would, but I mean, I think, Your Honor, if it pleases the court, I do believe there's enough in this affidavit that the court can proceed on both.
Okay, just take a look here real quick. Are you going to be representing
Judge,
Jason?
do you want Jason through him?
No, Judge, I will be representing Chantel, not Jason.
Okay.
Okay, have a seat.
Get the paperwork over here. I mean, if they've got one, could they bring?
Well, the affidavit should be downstairs, or a
I
copy of
have
the
an
affidavit.
affidavit right
Well,
here.
yeah.
Is it the same affidavit for both?
I couldn't tell you if it's the same exact affidavit for her.
I was, and I do express my gratitude to the Assistant State Attorney. He did give me an opportunity to look at the affidavit with respect to the co-defendant, Jason, I think.
Let me ask you this. Steve, is this a matter that you're going to be seeking to pretrial detention on? Or?
Yes, Your Honor.
Okay, so let me do this. I want to get the body of your client over here.
Yes.
Oh, I didn't realize they didn't have it.
We're going to order her to be brought to the. Just give me a moment. I'll do that. First name is Chantel, right?
Chantel, that's correct, Judge.
Okay. 2 Bravo. Could somebody over at Main Jail bring down Chantel Robertson? She's in 2 Bravo.
They're on it, Judge.
Okay, thank you. Just have a seat, sir. We'll come back to it, all right?
Thank you very much, Judge.
Okay, now, Ms. Razor.
Hello, Judge. Thank you for letting me an opportunity to come back this afternoon. I was in Dade County this morning. I am here.
Sing.
Yes.
Did I reset it for 1:30?
I think what you said is you would do it without prejudice. I don't know that it was formally reset for 1:30.
I didn't know you were coming. I did it without. I said significant bond without prejudice. So, if you'd like, I'll bring him back. And we'll
I would
readdress it.
appreciate it, Judge.
What is his first name?
Govind.
Govind Singh.
Gobind.
Gobind. Is there some way we can bring him down also?
I think he's in the main jail.
Govind Singh, Singh. He's on this morning's docket.
Let me bring him down. It's gonna take a few.
Yes, we'll get him. They're on it, Judge.
Okay,
Thank you.
yes, ma'am. You know what? You would have the, would you be able to print out where I set the bonds on that, so I'll just remember?
Matthew Patterson.
No.
Do you have an attorney? You're gonna hire your own, or do you want a public defender?
Got it. Okay. There you go.
Sign right here. Invoke the
Now.
Fifth Amendment.
We need to find a lawyer for you, right?
No, Judge, I don't think so. I've had a chance to speak to the state, I've had a chance, the city, I've had a chance to speak to all of the defendants who are in custody. The city is offering them, and they wish to resolve, time served on every one of their cases. I can repeat their names, unless it's confusing to the court. Jackus, he's at Conti. Robert?
That's a
Yes, sir.
Palco case though, right? Or is that,
What's that, Judge?
is that Palco? Jackass?
You could be right about that.
Copy, Your Honor.
Is that a Pompano?
Well, it's not for auto.
Okay, then. I will scratch that one, but I do have the others.
Jackass, have a seat up at Conti.
I'm sorry, Judge.
Okay.
Anthony Spranzo,
Anthony Spranzo?
that's at North Broward.
Franzo's so proud, Your Honor.
Okay, just give me a moment. I'm trying to find the paperwork here.
Go ahead.
Where was Spranzo this morning and I got?
Yes, Your Honor.
Was it?
Yes, it was a trespass. Can't find it?
See it here?
Don't
I
have it.
think I gave him an ROR on that. I think I did.
You
Let's
do?
go on to,
Okay, how about Charles Moore?
Judge, I'm sorry, I used to represent Mr. Speranzo. He had a VOP in front of Judge Porth. That VOP was resolved. The only thing holding him in custody was a municipal ordinance case. That's why, that's the only reason. I'm just saying that as a friend of the court. I'm not.
thank you, May I see Charles Moore? If you want to get Spranzo put back on the docket, I don't know where they are. Where's Charles Moore?
No, that was, Spranzo was first, and Charles Moore was
Moore
next.
is present at the main,
He's
Judge.
not present,
I
Mr.
don't have Spranzo's
Spranzo.
paperwork. I'll work it out, don't worry.
You want me to leave Franzo here?
We don't need Spranzo right this minute. Where's Charles
All right, but you
Moore?
want him to stay here today? I'm ready out, Your Honor.
So you're charged with a county ordinance. Is that something?
I know it's a county.
Well, look, you'll stand in anyway.
I would,
State what
Judge.
you're offering.
It was a time served. Oh, I'm sorry.
County ordinance.
That's fine.
You want to plead no contest this county ordinance drinking, I think, in public? You want to do that?
Do I want to what?
Do you want to plead
Do you
it
want to
out right
plead?
now? Do you want to work it out?
Yes, sir, yes, sir,
How
yes,
do
Your
you
Honor.
plead, sir?
Guilty.
Do you understand we're not going to have a trial? We're not going to appoint an attorney. The case is over with right now. Got it?
Yes, sir.
Okay, I'll accept that. Thank you. Now.
Okay, you're done, sir. Down the middle, out the door.
We'll see if you get paid on it. I'll sign it anyway, all right?
Thank you, Judge.
Charles Moore. Now, we got one more. Nelson Salado.
Later. Nope, sir.
No. I think it's the city of Fort Lauderdale. Sir, loitering. I think this is Fort Lauderdale. So would you like to resolve your case today? You can plead no contest. The case will be over with.
Yes, sir.
Do you need me to appoint an attorney to represent you, or can you do it without an attorney?
I could do without.
Okay, how do you plead, sir?
Guilty.
Do you understand we're not going to have a trial? The case is over with right now?
Yes.
Okay, I'll withhold adjudication. Thank you.
No, never mind. I was
Better go outside.
recess from this morning.
Got it. Okay, now, we've got some officers here waiting. Are you here on a specific case?
This is on Gary Gettian, reset from this morning, Your Honor.
Okay, let me find that. Gary Gettian.
Now, Your Honor, this,
I remember the
Yeah.
issue. Mr. Miller, we had an issue. You said that you believe that your client had legal authorization to be in that building, that he either lived there or was a resident there. Do you have anything about that? Do you have any more about that you can share with the court at this time?
Judge, I looked through every available avenue to me. At this time, I'm unable to provide the court with any documentation to indicate that he had a right to be there. That does not foreclose that we might be able to provide some in the future, but for today, I am unable to provide anything for the court.
Okay. We have some Hollywood police here, I believe, on this case, right?
yes.
Were you there when this, was anybody there when this, any first responders?
Sir.
You were? Come on up here, ma'am. We'll see if we can clarify the issue right now, all right? Raise your right hand, ma'am. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
Put your hand out. Tell me your name.
Officer Brittany Perez, sir.
Brittany Perez?
Sir.
And you're employed by the city of Hollywood?
Yes, sir.
Did you have an opportunity to investigate or carry out some legal duty regarding the arrest of Gary Gideon?
Yes, sir.
Tell me what part you took in it.
I was one of the first responders on scene, sir.
Your road patrol, right?
Yes, sir.
So when you got there, did you have a chance to come in contact with Mr. Gary Gideon?
I did, sir.
Okay. And State, do you want to ask any questions?
Did, Officer Perez, did you have an opportunity to speak to Raquel Davis, the alleged victim of this case?
Yes, sir.
And did you inquire of her whether Mr. Gideon had permission to be in the home?
I did, sir.
And did he have permission to be in the home based on the information you received?
No, sir.
And did you recover any evidence or information that he was a resident of that home at the time?
She stated that he did not live there and had not lived there since the last incident back in April.
Okay. And did, let me just ask you, there was the bottom of the front door was kicked out, correct?
Yes, sir.
Okay. And the door, I assume the front door had a handle on it, or doorknob?
Yes, sir.
Okay. Did it also have a separate lock, like a deadbolt?
At the top, I believe, sir.
Okay. And then there was an interior door that I believe had something kicked out of that also, right?
The northeast bedroom, yes.
Did it look like, from what I read, a big hole was kicked in it?
Yes, sir, from the handle up.
Okay, and did you see him holding a knife? Somebody said they came there and they saw him with a knife in his hand.
Yes, sir. When I was the first one on scene, he was sitting on the floor with 2 knives in his hand.
Okay, all right. And were you ever able to determine whether those knives came from in the house? Not that this, for this stage, necessarily matters, but do you know, were the knives brought in from the outside, or were they some knives that were in the house?
I believe they were knives that were obtained from the victim's home.
Okay. I don't know that I have anything else. Mr. Miller,
Can I
I'll let you ask a question or two if you want. In cases like this, I let him ask a question too. You have anything?
Appreciate that. Yeah, just a couple. Officer, part of your job is to do a protective sweep of the area when you cleared it. Is that correct?
Yes, sir.
And when you did that, did you notice anything in the home that could belong to Mr. Gideon?
No, sir.
No shoes, no clothes, no toothbrush?
Objection asked and answered.
No, let her, go ahead. Keep going, sir.
Allowed to object,
Go
Your
ahead,
Honor.
Mr. Miller. I'll let you ask that. Go ahead.
No shoes, no clothes, no toothbrush, no mail, nothing?
No, sir.
And did you look for these things, or is this something you would not necessarily look for in this case?
It wasn't something that I was necessarily looking for, but during my investigation, I saw no male clothing, nothing that belonged to a male subject in the home.
Okay, nothing
All right.
further, Judge.
Thank you. At this time, the court will find proof evident presumption great that the defendant committed count 2 of armed burglary. The court believes there's ample evidence, very strong evidence, that this defendant, based on the testimony of the officer, based on the affidavit this court has read, attached here too, that the defendant unlawfully entered the dwelling, which was owned by Raquel, or it was in her possession, and he entered that dwelling and became armed once in the dwelling. He unlawfully entered it by kicking in a door, and also the court, another analysis could be burglary of the bedroom she was in. I mean, one could even argue that she had closed herself off to the rest of the house, and that was his second burglary. If somebody wanted to get creative, he was armed when he went into that door. But suffice it to say, there's, in this court's opinion, based on all the evidence, that the defendant was armed. He was witnessed by this officer, Officer Perez, with the knives in his hand when they got there. So there is proof evident presumption great. In this court's opinion, the defendant will be held without bond as to count 2. Now, as to count 1, 3, 4, and 5. State, does this defendant have a criminal record?
Yes, Your Honor, and the state's very concerned for Ms. Davis's well-being. First off, Mr. Gedding is, and I've been informed, speaking with Sergeant Rhett Cady of the Hollywood Police Department, that Mr. Gedding is an A-level offender, considered by Hollywood Police Department. I provided the court with a probable cause affidavit from an arrest for aggravated battery on a pregnant victim, aggravated assault, and grand theft auto from April 29th of this year against the same alleged victim, Your Honor. And if you read the PC, you'll see it's very similar circumstances to the case that's presently before the court. Threats with a knife, threats to kill, refusal to leave the apartment, and that also occurred when the victim was pregnant, Your Honor. Other priors include 2009, he was convicted of aggravated battery against a pregnant victim and strong arm robbery with 1 count of misdemeanor battery. He was sentenced to...
What was that, Agbat?
2009.
Go ahead.
He was sentenced to just under 67 months state prison. In 1 moment, Your Honor.
The court does note on the prior arrest on April 29, 2015, it has the defendant's listed address, not the same as the alleged victim. He has an address on Northwest 19th Avenue, Oakland Park. She allegedly lives in Hollywood, so.
The 2009 case was a domestic violence in nature against a different alleged victim. 2009 resisting with violence and grand theft auto, he received the same sentence. 2008 burglary of a dwelling and grand theft, he received the same sentence. 2008 possession of cocaine, same sentence. Additionally, Your Honor, he was arrested in 2007 for domestic violence battery against the same alleged victim as the 2009 aggravated battery. That charge was dropped. In 2006, he was arrested for domestic violence battery against a different alleged victim, and that charge was dropped. 2005, he was arrested for aggravated battery on a pregnant victim and aggravated assault against the same alleged victim as the case before Your Honor today. That was dropped. 2005, he was arrested for another domestic violence, aggravated assault and culpable negligence against now what would be a 4th different alleged victim, and those charges were dropped.
Okay. Mr. Miller, is there anything you'd like to say about this defendant's ability to post bond for the other counts? Hi, ma'am. Are you a witness on this case?
This is the alleged victim.
Okay, ma'am, raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, put your hand down, ma'am. Tell me your name.
Raquel Davis.
Okay, ma'am. And are you the same Raquel Davis who's the alleged victim in this matter and the matter from April of this year?
Yes, sir.
Okay, ma'am. And were you the girlfriend at one point of Mr. Gary Gideon?
Yes, sir.
And when did you stop becoming his girlfriend? When did the relationship end?
We never necessarily called off the relationship. I'm currently pregnant with his child. However, since the last incident, when he came out, I just asked him to stay away and get himself together. He said that he was going to go get mental help because when he came out of prison the last time, They told him to go to Henderson Clinic, and he never did.
Let me ask you now. Where does he live?
Well, he was living with his aunt. When we worked together heavy, he was back and forth at the house. But ever since he got out the last time, I just basically asked him to stay away. He's been staying with his dad.
Okay, and when you say the last time he got out, you told him to stay away, what, would get out of prison?
No, when he recently got out of jail about a week and a half ago.
He got out a week and a half ago, and since then, you told him to stay away from your house?
Yes, but that's what's the issue.
Do you have a key to your house?
No, not at all.
Have you ever let him have a key?
A while when we first started talking.
He doesn't have a key now?
No, not at all.
Is it
The
when he comes
locks are
over to your
changed.
house, does he have to knock on the door for you to open the door?
Yes.
Okay, so he doesn't have any way to get in the house, and he can't just open the door and come on in?
No, not at all.
Okay, all right.
Ma'am, and
Does he ever keep any of his belongings in that house?
He did, but that weekend I took his stuff to his dad's house.
Okay.
Where he was staying, and I had an incident there too. I just never called the police.
Let me ask you, are you in fear of him?
Yes.
Okay.
At this point.
Other than these two incidents, this incident that happened June 22nd and the incident that happened back in April, have there been other times where he's allegedly abused you, ma'am?
We had other situations. The police was just not called.
Okay. Go ahead, Steve.
Just, Ms. Davis, because I believe you said something, I don't know if the record would have picked it up. Since the last time that Mr. Gideon has had the keys to your home, you've had the locks changed?
Yes.
Okay. Your Honor, just for the record, I just want to note, from his May arrest for the aggravated battery and aggravated assault grand theft auto, when the charges were dropped, he was released from Broward County Jail June 12th of this year. So approximately only 10 days passed before these new allegations.
Okay. Mr. Miller, let me ask you, is there anything you'd like to say regarding this defendant's ability to post bond? Go ahead.
Can I ask the witness a couple of questions?
I'll give you a little leeway, but, you know, let's be...
and Your Honor, I want to make an objection for the record. I would oppose because the court has already found proof evident presumption great. There's really nothing factual for these questions.
You know what? I'm going to agree with the state. We're beyond that. Why don't you tell me which question you would ask, and I'll filter it. What would that be?
Okay, I would like to know if she picked him up from jail when he got released the last time.
Okay.
I would like to know if he pays for the Comcast bill and if the bill is in his name. I would like to know if he's the one who changed the locks, or did she pay someone else to do it?
Okay. All three of those, with all due respect, I don't think are relevant to this hearing today. That could be brought up in a deposition down the line, but today we're not going to go down that road. Let me ask you.
I believe this potential new evidence has an effect on whether or not proof evident presumption great can be found. If there's any indication that he had some right to be there or some purpose for being there, then the burglary doesn't stand and he's entitled to a bond.
Well, you know, I'll give you an analogy, and I'm not going to get into back and forth on this, but he could have even paid her, the man, to cut her lawn. That still wouldn't give him the right to go in the house. And even if he's paying her light bill or paying her cable, that still doesn't necessarily give him the right to be in the house. So that being said, do you have any comment about his ability to post bond before the court sets bond on the other counts?
Well, Judge, he has no money, and he did have a job, but he's going to lose that now, so he has no ability to post any bond.
Okay. So the court believes you represent an extreme danger to this alleged victim. The court does note there's a history of domestic violence dating back to 2005. You've known him since then, right, ma'am?
No, I've only known him.
Is that a different victim?
Yeah,
sorry.
that's his other
Okay.
baby.
Sir, dating back to 2005, you've been arrested for aggravated battery, domestic violence battery, aggravated assault domestic, 2006 domestic battery, 2007 domestic battery. Those were all dropped. The court knows that. 2008, burglary of a dwelling, grand theft, cocaine. Then 2009, 67 months in prison for aggravated battery in a domestic case. And then resisting arrest with violence. So you have a history of violence on women. Now there's a pattern of violence toward Miss Davis. The one in April we talked about. I'll read right out of that. I'm looking at the probable cause affidavit prepared by Vinicio Perez. Victim Davis, alleged defendant, then grabbed a steak knife from the kitchen, charged at the victim and threatened, "I will kill you, ho." So allegedly threats to kill her then. Then in the case we're here on today, observed a large butcher knife sitting by the defendant, lying on the floor. The defendant was found with knives. He allegedly kicked open the front of the door. The officer had to deploy a taser on the defendant. This just is, if you call the police, here's a quote, "If you call the police, I'm going to kill both of us." So the court's concerned, sir, that one day you will carry this out, or you want to carry this out, but right now the court's going to do its best to prevent that from occurring, and the court is concerned with the history of violence and the violence in this case. Count one will be $250,000. Count two, you'll be held no bond on the burglary, battery, second or subsequent offense. On count three, that bond's going to be $100,000. False imprisonment, that bond's going to be $100,000. Resisting arrest, that bond will be $100. So you're going to be held without bond on count two, but count 1, 3, and 4 are going to be $450,000. There'll be pretrial release if he ever makes a bond. GPS, I'll waive the cost. And then court will order no contact with Raquel Davis directly or indirectly. Stay 500 feet from her at all times. You're not allowed to possess guns, weapons, firearms, or ammunition while you're on release. Ms. Davis?
We would just ask that be level 1 supervision.
Level 1 lockdown if he ever makes bond, but that's kind of remote.
I understand.
Ma'am, thanks for coming to court. Sorry we had to meet under these circumstances, all right?
Thank you.
Want to thank the officers for coming in. Thank you. All right, may I see, do we have, Chantel Robertson, do we have Miss Robertson in the courtroom yet? Chantel Robertson. I'm not sure if they got her yet.
Present at the main, Judge.
Thank you. You may need to fill out. Got it. Ms. Reisman, did you see Singh's PC?
Yes, I did, Your Honor.
How many copies?
Okay, Chantel Robertson.
He's going to want one.
Come on
I'm
up.
going to want one.
Thank you,
Stand
Judge.
right now.
Let me just take about a minute and
May I
review
get a
this
copy
document,
of-
all right? I'll be right back. We're back on. Now, State,
Yes, sir.
we have Ms. Robertson before the court. Could you state your name for the record, please?
Yes, Judge. My name is Franz Park, and I have been retained by Ms. Robertson in this matter, Your Honor.
Mr. Park, I think you've been in here before, haven't you?
Yes, I have, Your Honor.
Sir,
I've had
okay.
the privilege of appearing before you before, sir.
Again, sir.
Thank you, Judge.
Your client's been charged with robbery with a firearm. She has a co-defendant who's also been charged that way. Now, State, are you seeking foreclosed bond and release conditions? This is your first-degree felony punishable up to life in prison. Now, the state is seeking to foreclose bond and release conditions, I assume, on both defendants. Correct?
Yes, Your Honor.
Now, State, go ahead and tell me why you think that there's proof evident presumption great on Miss Robertson.
Well, Your Honor, I would argue for Mrs. Robertson, based on the allegations, she was apprehended by loss prevention at Walmart, stealing property, namely 2 holsters and earmuffs that are hearing protection for shooting, Your Honor. She was taken back to the loss prevention office, which point she was on the phone with Mr. Robertson. Then loss prevention got on the phone with Mr. Robertson, and it appears that is when Mr. Robertson became aware of where Miss Robertson was located. Mr. Robertson appeared at the loss prevention office. He couldn't get in at first. There was a lock, numerical lock, preventing him from entering. He tried kicking open the door. He then pulled out a firearm, according to a report, and one moment, Your Honor, ordering the assets protection staff member to open the door. It was only at this point that the staff member, fearing for his life, complied and opened the door. The staff member fled on foot, and then Mr. Robertson struggled to push the door open, and then with the assistance of Miss Robertson, was eventually able to open the door. They both fled the store with the property still in Miss Robertson's possession.
Let me stop you right there.
Yes, Your Honor.
That is the salient point we need to analyze. Up to the point she's in loss asset prevention or loss prevention, whatever, when she's in there, the only crime she's allegedly committed is a theft of store goods.
Yes.
Now, according to this affidavit, according to you, there's a line that got crossed right in there somewhere, and I believe that the salient facts here, or the salient issue is, what type of assistance did she give to make an escape?
Actually, Your Honor, no, you can't. Actually, I don't think you can separate them under the law of robbery, because if you read the law of robbery, it means the taking of money or other property which may be the subject of larceny from the person or custody of another, with intent to either permanently or temporarily deprive the person or owner of the money or other property, when in the course of the taking there is the use of force, violence, assault, or putting in fear. In the course, if it occur, an act shall be deemed in the course of committing the robbery if it occurs in the attempt to commit robbery or in flight after the attempt. So even if it's the use of force is done after the attempt, that's what makes it the robbery, Your Honor.
I don't dispute that, but what I'm saying is that
And an act shall be deemed in the course of taking if it occurs either prior to, contemporaneous with, or subsequent to the taking. So the fact that it occurred after the taking still makes it a robbery.
here's my issue. She's in the room. He's basically breaking into that door with a firearm. Where I am not sold is that she was trying to make an escape, or was there a man
Well,
with a gun? She figured she better get out of there with him because he's the one with the gun.
It's her husband, and she left with him.
He had a gun.
It's her husband, and she left with him. They left together. They came together. They left together. The employee didn't leave with him.
Let me ask you this: do you think that?
And if she was in fear, why was she assisting him in opening the door so she could get out?
I don't think she assisted.
It says it. It says. Your Honor. The black male accomplice was able to reach inside the Assets Protection Office and remove the suspect, who was attempting to escape the Assets Protection Office by assisting her accomplice in opening the door. You have to go by the facts, Your Honor. You may not like them, but that's what they are. That's what the allegation.
Like them or dislike
But to disregard them would seem to indicate that you just choose.
not disregarding them. I have to determine whether it's proof evident, presumption grade. I could find there's probable cause for an armed robbery. And I definitely believe these two, the male sits in a different position than the female. The question is does the female rise to the level?
Here's the question, Your
male
Honor. You asked the question, what evidence is there? It's right here. They said she was assisting in escaping. Now the question is there any evidence that suggests different? And there is not. So the question is, with the proof, uncontroverted, yes, that is proof evident, Your Honor. And that's why I'm saying, to say, it would seem to me that the court does take issue with the facts if the court chooses to disregard uncontroverted facts.
Your Honor, I respectfully submit to this honorable court that the facts on the four corners of this affidavit do not rise to the level of proof evident and presumption great with respect to the armed robbery charge against the female. The female was apprehended, was being detained. Another person who happens to be the male comes from who knows where, and he tries to break into the place. He assaults persons, and thereafter the persons who were responsible for maintaining the custody of my client fled. He entered the room and with the firearm, putting my client obviously in fear, she left with him. I mean, this is what transpired, Your Honor. And I'd respectfully submit, sir, that whereas there is clear evidence that she's committed a theft, I would humbly submit to this honorable court that these facts or allegations do not rise to the level of proof evident and presumption great for an armed robbery.
I'm going to agree with the defense. The court does not believe for this defendant it rises to the level of proof evident presumption great. The court is not 100% sold on the opening of the door, what part she took and said assisting. It says here, the black veiled accomplice was able to reach inside the asset protection office and remove the female suspect who was attempting to escape the asset protection office by assisting her accomplice in opening the door.
She also, Your Honor, because she said maybe she was leaving just out of fear. Then why did she take the stolen property with her? The court's also not noting the fact that she was on the phone with him before when she was brought there. How did he know where she was?
She probably said I'm in the asset protection office.
And that's certainly an argument that why, to get her out of there.
Okay. All right. So
Your Honor, I'm just making a record because I'm very alarmed that the opposing theory is that they weren't acting together. He broke in for no reason into the room, because if it wasn't to get her out, then there was no reason for him doing this. And his wife, out of so much fear that he was going to hurt her, left the scene with the stolen property with the man that she was afraid was going to hurt her.
Okay. Now, please inform the court whether this defendant has any criminal record.
Your Honor, I'll need a moment to do that.
Tell me about your client.
My client works with Comcast Cable, and she has worked there for 3 years, Your Honor. She has no prior convictions. She is married, and she has no children. She has lived in Florida for at least 5 years, and I'd respectfully submit she's not a person who would flee from this jurisdiction. She has no children, Your Honor. She does have a very close friend in court whom she... Please stand up for me.
Oh, hello, ma'am. What's your name?
Natalie.
Natalie, how do you know Chantel?
I met her when we started working at Comcast.
Oh, really? Okay, great. All right, what do you two do at Comcast?
We work in the sales department.
Great, okay. That's good. Thank you for coming to court.
Okay, and she was a friend of my cousin's from their previous employment. That's how we got so close.
Really? Okay, that's great.
Your Honor, all I can say, I see no record. I would note, just with the mitigating argument the defense made, I don't think the fact that she's married is really much of a mitigator, considering her spouse in this case is her co-defendant.
Okay, court's going to set Miss Robertson's bond at $7,500.
State would object to such a low bond on this case.
Based on this, based on the facts of the case, the strength of the case against her doesn't rise to the level of proof evident presumption great in the court's opinion, but it does rise to a pretty significant level. Don't go back to Walmart, ma'am. Thank you. Now.
Your Honor, I'm going to ask for no contact with the co-defendant.
What's his name?
Jason Robertson.
Jason Robertson. No contact with him. May I see Jason Robertson?
Thank you very much, Your Honor, and do have a very good evening, sir.
Stand by. We're going to take care of Mr. Robertson now, too. Let's see.
Yes, sir.
Mr. Robertson, you're charged with robbery with a firearm. You're charged with aggravated assault with a firearm. So you're seeking a foreclosed bond and release conditions?
Yes, Your Honor.
All right. Now we know the facts, allegedly. Mr. Miller, is there anything you'd like to comment about regarding these facts?
Judge, Mr. Robertson has declined the services of the Public Defender's Office.
I understand. Mr. Robertson, let me ask you, sir, what do you do for work right now?
J.C. Penney.
Do you have any money in the bank?
No.
Okay, sir, the court today is going to find proof evident presumption great that you, in fact, committed an armed robbery of a Walmart by trying to spring your girlfriend out of the Walmart asset protection, allegedly used a gun to carry this out. And I want to note right here, you were identified by the cashier, Andrea Williams, 99% positive, identified Miss Robertson, 100% positively identified you as a suspect. And then I'll go down the line here. Medgar Dunkley, 100% positive that you were the suspect. Asset protection employee, William Jarrah, 100% positive you were the suspect. Rodney Michelle, 100% certain you were the suspect. Fernando Cortez, 100% positive you were the suspect. Manager, Juan Rodriguez, he didn't observe you. So, sir, the alleged fact that you use a firearm to commit this crime, based on these facts contained here too, you're going to be held without bond on count 1, count 2. Your bond will be $50,000. You're not allowed to have any contact with Chantel, what's her name? Robertson. Chantel Robertson, no contact with her directly or indirectly. You'll be held without
So what are
bond.
the charges against me, Judge?
Robbery with a firearm, count 1, count 2, aggravated assault with a firearm. Thank you. You'll be held without bond. Okay, now, let's call up Gobind Singh. Thank you.
Sir, straight up the middle, go outside and have a seat.
It's all right. Good.
Good afternoon, Ms. Robertson.
Good afternoon, Your Honor.
Hi, your client, Mr. Gobind Singh, came before this court in the morning docket.
Correct,
And
Your Honor.
at that time, this court had reviewed the affidavit regarding DUI. The court noted the client has a DUI which is on appeal, so there was no bond revoked. The court didn't have jurisdiction for that. However, this court did note that he did have a recent DUI, and that also that the strength of the case of the defendant against your client was, in this court's opinion, rather strong. Someone at the home that he left from said he had too much to drink and that he should not be driving, and that he drove anyway. And then several people at the scene of the crash, and the crash involved allegedly him smashing his Maserati and putting a Toyota, I believe, on the hood of the vehicle. And then people who either were there when he first got out of the car, there's a wheel witness there, a couple wheel witnesses, they said he appeared to be drunk, he appeared to be intoxicated. So the court did note the strength, the court did note the recent DUI. The court also noted the alleged damage and the dangerous behavior by driving up in somebody's lawn like that. So I set his bonds in a significant amount, but I did so without prejudice. I set his bond total at $90,000. So
If I could address a couple of matters, Judge. Okay, in regards to the strengths of the case, as it relates to the DUI portion of the case, there is only one admission by one officer that he had an alleged odor of alcohol on his breath, bloodshot, watery eyes, and his speech was slow and slurred. But he was in the car. In fact, the airbag engaged. And some of these observations, but for the odor of alcohol, can be consistent with the fact that he had a head injury, which is what is stated in the police report, that he had a head injury, and he was transported to the police department. There's really nothing much there in regards to the strength of the DUI itself. That he had an accident, yes. That it was a bad accident, yes. But in regards to the strength of the DUI, I really don't see it. He refused everything, including field sobriety exercises and a breath test. In regards to this alleged person or relative of his, I spoke to his family members, and no one had any conversation with the police, and I believe that there was no recorded statement of that person who represented himself as an alleged family member. And none of the family members who I spoke to this morning before coming here today said that they had spoken to the police. As it relates to Mr. Singh, he only has one prior DUI, and obviously we were going to be contesting this DUI. What I'd like to see, as far as there being proof evident presumption grant, I'm not worried about that. I do request the court to see if he could revisit the amount of the bond. I do think it's excessive based upon the fact that it's only his second, potentially, DUI. As far as the case on appeal, I'm very familiar with the case because I litigated it. It's a motion that I won on several grounds, so I don't think I have a very good case on appeal. So I don't think that that's relevant. And I do have a proposition that I think the court should consider, which is something that he would like to do, and that would be inpatient treatment. I heard what Your Honor said, but I think that in this particular case, since there's a circumstance of alcohol involved and the client wants to voluntarily participate in the program, as a special condition of his release with a reduction of bond, a mandatory 90-day from facility to treatment, bed to bed, so there will be no release into the community. And obviously, pretrial can monitor that, and then any outpatient that is recommended. I think that that's something we would like to suggest to the court.
Is he allowed to have an ankle monitor on in this facility?
He is not allowed to have an ankle monitor. However, because he's going to be monitored by pretrial, they call them immediately upon if he leaves. It's going to be inpatient lockdown. He's not going to be allowed to go out. And they'll pick him up at the jail.
Well, the thing is, Frank, I mean, to be honest, I think with the bond and the conditions the court said this morning are appropriate. I don't believe the court can require 90 days. That becomes, once you set an amount of time, then it becomes a sentence. That's my understanding of it, Your Honor.
You know what? Let's put it this way. If it is agreed to by the defense, I mean, it's the defense's
proposition. It's my
proposition. I'm not sure that they can turn around later on and say, aha, you punished me, when, it's they're coming forward. That would be kind of a...
I guess the only other...
I don't know anybody can make that argument with a straight face. You know what I mean?
I guess the only other issue is just, I would think the court would want more information about what rehab facility we're talking about here. I mean, it's just, it's all in the abstract at this point.
Well, Mr. Reyes, do you have one in mind?
We're trying to see which, I had very short notice. So, I mean, it's for me to give you the name of the facility, I don't, but obviously as an officer of the court I can represent, it's going to be a legitimate facility. He's going to live there and it's going to be locked down. So it's not like he's going to be able to come and go. And the program will pick him up at the jail. So he's not going to be released to the community and then have to voluntarily surrender to the program.
Yes, ma'am. You want to reset this for tomorrow afternoon? You figure out where you want to, where this.
That would be great. That would be
Set
fantastic.
it for tomorrow afternoon. Work on this, and we'll work on bringing the bonds down tomorrow. Okay?
That would be great,
Can I
Judge.
give you a little bit of a compliment?
Absolutely.
We go back a long time.
Yes, Your Honor.
Back when I was an assistant state attorney. And as you stand there, I remember I had a case that I thought this guy was guilty as homemade sin, and I was going to prove it. And I remember you absolutely wore me out in that trial. The jury walked a guy I thought was guilty as homemade sin, and I learned a lot from him. And I still to this day, every time I see you in a very complimentary way. I think how you beat me in a trial, that I thought the person was definitely guilty, and I thought the jury was going to do it. And I think you found
Thank you,
that
Judge.
guilty, so.
Thank you. So I will be here tomorrow. My husband's having cataract surgery in Miami in the morning, but I believe I should be back by 1:30, Your Honor. Thank you very
See you
much.
tomorrow.
Thank you, everybody.
Yes.
All right, we'll see you
All right,
tomorrow.
sir. You'll be back tomorrow. Go and have a seat outside.
Okay. Now, anybody else here on another case, or everybody here on that case? Another case, you all together? Who was here first? You were? Come on up. You've been here since 10:30? Come on up. Uh-oh.
They told us to be here by 11. I came to support.
What? All right. Yes.
Thank you, Your Honor.
Okay, now, where is, which case you here on, man?
Raglan. Raglan.
Man or woman?
Yeah.
Raglan? Now, Mr. Jakari Raglan, you're charged with grand theft auto. Court finds probable cause. State, do we have any priors on this gentleman?
Do you have anything? One moment, Judge. Cease, do you have anything?
No.
Okay. State, do you have any criminal record?
No, Judge.
No criminal record, all right. Allegedly, he stole somebody's PT Cruiser, convertible. Could I have both, it was caught on video surveillance, allegedly. Could I have both of you raise your right hands for me? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, put your hands down, ma'am, right up front here. Tell us your name.
John Davis.
And how do you know Mr. Raglan?
That's my son.
Thanks for coming to court. You, ma'am?
Shalonda Williams.
And how do you know Mr. Davis?
My cousin. Our boys are the same age.
Okay, got it. All right, well, I'm going to set his bond today at $1,000, so you could just bond him out of jail, all right? I appreciate you coming to court. I'm sorry we had to meet like this, all right? All right. Now, here's the good news. How old is he?
19.
Okay. Well, let me say this. He's got no criminal record. He's 19 years old. When he goes to court the first time, he should ask to be put in a program. Was it a pretrial intervention program or something like that? I don't know. They have another name for it now. Has to be put in a program, and they may be able to put him in a program where this won't go on his record. All right.
Thank you.
I think they call it. What do they call it now, Mr. Miller?
Last I heard, it was PTI, Judge.
Pretrial intervention or a diversion program. Okay? He has to ask the first time he goes back to court, all right? Ask the judge when he gets in there, okay?
Okay.
Thank you.
Thank you.
Okay, now, let's see here. Let me call Shade up. Which case are you on, ma'am?
Lawrence McCray.
Mr. McCray?
Mm-hmm.
You have Mr. McCray over there.
We have a Lawrence McCray in North Broward, Your Honor. Is that him?
Is that the second one? Is it? See? This this a,
It's a 30-day.
30-day?
As long as he understands, actually,
I have something
Casey,
to say.
are you showing he's already been ROR'd on these? He's not being held on these anymore. 8, 9. Really? On BSO pics, I'm showing no info.
It shows no info. The case been input wrong. I've been down here like several times.
I don't know about that. I just know 156551 CF10A.
No info.
I mean 66. Yeah, they just have the
Wrong
okay.
case. Wrong case number. Everything been no info.
Man, oh my God.
We're working on it, okay?
Okay. Yeah, he can be ROR'd. He's just, as long as he understands, well, whether he does or not, he's not going anywhere. He's being held.
Was it no info or not?
No, it wasn't no info. From what I can tell, he's entitled to an ROR, but on another case, he's being held no bond on a court order. 3 counts of grand theft auto and 1 count of dealing stolen property. He's not going to get game time.
The state has not filed a formal charge on you today on count 8 and 9. They've not filed a charge. I can release you on your own recognizance on these 2 counts. However, as a practical matter, you're not really going anywhere. You're going to stay in jail because there's a court order holding you on grand theft auto.
The court order was it was because I caught new charges. The new charges dropped.
That doesn't.
All of the new charges dropped.
It's up to him.
Okay, I'll release you ROR. Granted. All right, sir, on case 15-6655 CF10, the motion to release you ROR is granted. Thank you very much. All right? Thank you, ma'am.
Okay.
The other charge, Your Honor.
Sir.
The other charge is I can't be reinstated on bond or ROR.
Not today. Excuse me. Not today. Thank you.
A little bit, please. A little meeting.
665, 15-665, I think.
See, in BSO pics, you have it as 6551, and it should be 6. It should be in the system 6655. It should be 6655. But you guys have it as 6551. I'm shocked.
Sure. Take a couple-minute break. We'll be right back. Let's see Georgette Rosenfeld.
There would be no fasting, but the other problem is you're not allowed to drink alcohol, so I'd have to figure out a way around that somehow. Out of the heading of 2 wrongs make a right.
Georgette Rosenfeld.
That's the least of it for me right now. Holy shit. I don't care about that right now.
That's not Broward, Your Honor.
What's that? I'm not kosher.
Hi, Miss Rosenfeld.
Hello, Mr. Judge Hurley.
How you feeling today?
I feel terrible.
Why? What's wrong?
I'm sick.
What do you have? I mean, do you have a cold or something like that?
I don't know what's wrong.
No? Well, yeah. Hi, Miss Rosenfeld. What would you like to do?
I don't want to leave here. I don't want to go outside.
I know.
I can't you put me in the program here
Yeah.
for drinking? I'm an alcoholic.
All right. Okay, so I'm going to put you on count 1 and 2, 100, 150, count 3 ROR. Can you give me an order for SAP? We're going to put you in the SAP, all right, ma'am?
Okay, yes.
Good luck, Mr.
Will the court appoint shade on the case? I think the last case is a capias.
All right, big. Yeah, can I have a shade now?
Dude, I didn't know that.
Yeah, do you mind? Is he Christopher Lasky? Dragging this afternoon. Mr. Lasky, you're charged with domestic battery, resisting arrest. The court finds probable cause. State, does Mr. Lasky have an open case right now?
He does not have an open case, Your Honor.
I'm being charged with more than one charge?
Sir, you talk to him. I have no idea.
We don't know how long that takes. Judge, on 14.
I don't see an open charge, but he does have resisting without violence from last year, grand theft, 2 separate grand thefts from 08 where he violated probation, was sentenced to 20.5 months state prison. 08 child neglect with a VOP, same sentence.
Okay. Was there any contact with the alleged victim? No. Okay. Mr. Miller, anything you'd like to add?
Judge, I did not get an opportunity to interview Mr. Lasky if the court wishes to inquire.
Lasky, are you working at this time?
I'm in between work right now, sir, and I'm looking for more.
Okay, and how long have you lived down here in South Florida, sir?
33 years, sir. I was born in Broward General.
Got it. Do you have any money in the bank?
I get money in monthly, and then I have other accounts with my family that it's involved with.
All right, sir. Sir, it's alleged that you've been dating Miss Harda for about 4 years. Says you became
Yes, sir.
irate, started to scream, grabbed her, causing contusions to her arm, struck her in the back of the head with an open hand, grabbed her by the throat while she was driving, saying, "I'm going to kill you." Grabbing the steering wheel and stating, "I'm going to kill everyone in the car," turning the wheel so that the vehicle crashed into a bus stop on Lakewood Drive. Allegedly, police came in contact with you. Said you poured out 2 bottles of Jack Daniels into a drain and along with some pills. Says, when the police took you into custody, you allegedly told them, you touch me and I'll F you up. I don't give an F, I'll kick your ASS. And it says that you tried to go after the police officer. Somebody had to hold you back. And it says the victim further stated that if the defendant was released from jail, he would kill her. And it says that you threatened to kill everyone around you when you were being taken into custody. And I don't know what this means. It's a little, it says, he further stated we would be at his house with Coral Springs removing his girl. So the court believes that is, maybe was a veiled threat there, but, sir, I'm going to set your bond based on the level of violence, your threats made, you, frankly, the alleged bizarre behavior, grabbing the wheel, turning it into the bus stop. I'm going to set your bond on count 1 at $10,000. We're going to set count 2 at $5,000, and the court will order your bond's $15,000. You'll have pretrial release, GPS monitor. The court will waive the cost of the monitor. You're to have no contact, directly or indirectly, with Jessica Harda. Do not call her, text her, or email her. Stay 500 feet from her at all times. That's where she lives, works, goes to school, anywhere in between. You're not, have that back. You're not allowed to possess any guns. Can I have that back? Thanks. Not allowed to possess any guns or weapons while you're out. The court's going to change your bond on count 1. The court doesn't feel comfortable with that. The threat to kill, the court's going to raise your bond on that to $40,000 on 1. Your total bond's going to be $45,000. Second thought on that, sir. You've threatened to kill the police. You threatened to kill her. Your bond's $45,000. I'm sorry about that. The first time missing that.
Over here, why? No. I'm still reading. This detective.
We're ready, Judge.
The monsters.
Fabian.
Come on.
Okay, now.
This guy.
Just give me a quick moment.
What's that?
Leisure Fabian.
President Domain.
So you've been charged with pretrial release condition violation. Court finds probable cause. I remember the defendant being in here the other day. Allegedly got into it with his wife and daughter.
His wife was found unresponsive but breathing. She was hit in the head with the speaker box.
I remember this.
The other daughter had a blood on her shirt, small cut to her chin.
This is approximately 1:47. Responded to the home, and there was a domestic disturbance. Upon arrival, observed the defendant exit the above listed at residence, where he had an altercation with his daughter, whom was present at the location. Okay, say what's the case he's out on?
156696 MM10A.
Okay, so I'm going to go ahead and set your bond today at $2,500. I'm going to assume you have no money, and Excellent Ties Community Court's going to revoke your bond on 156696 MM10A. Your bond's revoked. You're going to be held without bond. I'm going to remind you not to have any contact directly or indirectly with the alleged victims, Alicia Fabian and Nina Fabian. Thank you.
Thank you, Judge. Good luck. Burbage.
Mr. Burbage, you're charged with battery and resisting arrest. Excuse me. Court finds probable cause. State, do we have any priors on this gentleman?
One moment, Your Honor. Do you have anything? I gotta sign it again.
No? Okay. Mr. Miller, any contact with the alleged victim?
Yes, the victim is not in fear and someone trying to arrest.
Okay. The alleged victim is not in fear and does not want to pursue charges. Anything you'd like to say, Mr. Miller?
Judge, we're going to need a photo order for Mr. Burbage. A mental health screen.
Okay.
He's just finishing.
And in light of the alleged victim's desire not to prosecute, I would ask the court to consider pretrial release for him.
Okay.
And to include the mental health eval as a condition of his release.
All right. Does he have any money to bond out? Do we know?
No, Judge.
Sir, are you currently employed?
No, I'm not employed at the time.
No? Okay. I'm going to, sir, you allegedly headbutted your wife. The police got there, and they said they saw swelling on the bridge of her nose and redness. And said you were continually argumentative. All right. Just look here. Okay, sir, I'm going to set your bond today on count one, the headbutting. That'll be $5,000. Count two, you'll be released ROR. It's based on the level of violence the court's concerned and the safety of the alleged victim. Sir, I'm going to order you have no contact directly or indirectly with Sasha Burbage. Do not call her, do not text her, do not email her. Stay 500 feet from her at all times. That is where she lives, works, goes to school, anywhere in between. You're not allowed to possess guns, firearms, or ammunition while you're on release. Thank you, sir. How about Edward Leahy?
North Broward, Judge.
Edward Leahy, is he up there?
Yes, Your Honor, you refuse.
He refused.
I thought there was an order that they weren't. Yeah, there was. Judge.
Okay, he refused to come to court, so I'm going to do this. I'm going to set his bond at $10,000 today.
Well,
Put order pretrial release with the GPS monitor. And he can bond out. And what I'll do is I'm going to bring him back and advise him tomorrow afternoon. So tomorrow afternoon, if he isn't here, we'll go to Plan B.
But obviously, if he does bond out, Patrice, would pretrial be able to inform him of the judge's order of no victim contact? Thank
Just have
you.
no contact. directly and indirectly to Lorraine Leahy. What do I think this is an alcohol issue? Okay.
Well, that's the thing. They're supposed to do. I mean, they can do whatever they let them do, but they're not supposed to. Like, since when you get to decide when you come?
Did you speak with Miss Leahy? No. Okay. All right, James Carter.
Main jail.
Jesus Sanchez, please come on forward. When I call your name, line up. All right, Mr. Carter. Count 1 is battery, domestic violence, possession of PVP, known as FLACA, license suspended, altering a sticker on your tag, and then you have 3 counts of traffic infractions, probation violation on count 8. Do we have any priors on this gentleman? Do you have anything to say? I'm going to set his bond. Count 1.
Yes, Judge, lifetime resident of South Florida. He's been living at the same address for the past year. He works at a landscaping company called Coast Cutters.
Close.
What?
Close cutters.
Clothes Cutters. He has 2 children he takes care of, age 8 and 10. He had no money or real estate. He does have a place to stay separate from the alleged victim, and when he bonds out, his family will be doing it for him.
I just have the DUI that he's on probation for count 8.
Okay. So I'm going to set your bond. I read the report here. Let me look here.
We need to talk about that.
We're going to set your bond on count 1 at $5,000, 2 at $1,000. You're going to be held on count 8, no bond. And you're not allowed to have any contact with Alexa Lewis directly or indirectly. Stay 500 feet from her at all times. Thank you. No guns or weapons will be in your possession while you're out of place. Missy Jesus Sanchez.
The last case we did.
President, the main judge.
So you want it out of state. No bond on count 1, count 2. You have a purge amount, it looks like, out of another state, $675. Thank you.
Judge, we're going to see him Thursday in extradition court?
Probably. I don't set that docket, but usually that's the way it works.
Okay, thank you. All right, you're good. Down the middle, out the door.
How about Natalia Miller, Maniela
She's at
Joseph,
prison.
and Alexis Lewis? Please line up.
Natalia Miller's president of the Maine. She's declined the PD. His name's Carter, right?
All right. Sorry about that little interlude. Okay, we're Natalia Miller, DUI, ma'am. DUI property damage. Count 2, 3, 4, and 5. Count 3 and 4. Count 5. Open alcohol. You said you had a bottle of Remy Martin cognac in your purse, which was open. Said you became belligerent.
There's evidence.
And you allegedly ran into 3 bumpers of 3 cars. And then, there you go. So, and then I'm looking at her driving record, and it looks like a pretty good driving record here. Go ahead, state anything.
I don't see anything. Do you have anything?
Ma'am, are you working at this time, Miss Miller?
Yes, I'm working.
What type of work do you do?
I am working in Fisher Island. I am property manager.
Property manager on Fisher Island, okay. Ma'am, who's going to bond you out of jail today?
Who's going to post your bond? So you
My daughter.
Okay.
She
All right,
will,
ma'am.
yes, she will.
Ma'am, you're not allowed to consume any alcohol while you're on bond, all right?
Okay, I promise.
A drop of alcohol and you go back in jail, okay, ma'am?
Never.
You only have 10 days to go get a temporary driving permit at the DMV. Thank you. How about Maniela Joseph?
Okay. Over here. Miss Joseph, Judge.
I see, ma'am, two petty theft warrants, 1,000 on one, 500 on two. Thank you. How about Alexis
The
Lewis?
judge on Thursday. Okay, Thursday. Judge, President of Maine, we have a bit of an argument.
Ma'am, you're here for possession of PVP, which is also FLACA. Go ahead. What is your argument, sir?
Judge, this is the co-arrestee with Mr. Carter, who was just here a moment ago. He was charged with domestic violence battery against this woman. According to his probable cause affidavit, the police officer saw him hand her the bag that contained the alleged PVP. She stated in her police report that she was afraid to refuse it based on the domestic violence that she was receiving from the man who handed it to her.
Right.
Judge, under those circumstances, I would ask the court to find no probable cause or in the alternative to release her on no recognizance.
Well, I appreciate the argument. I'm not quite sure we're going to do that. Let me find out. Does she have any prior state?
Yes, Your Honor.
Go ahead.
Her record includes false info to law enforcement during investigation 08, resisting without violence 07. What? She has a...
Yeah.
Oh, I'm sorry, Your Honor. She was arrested beginning of this month for... Is it neglect?
Is that still open?
Yes. One moment. Yeah, basically, their children were left unsupervised at their apartment.
What's the case number?
Case number is 157199 CF10A.
Ma'am, you're out right now on a felony of child neglect, leaving your children at home alone, and now you're allegedly involved in FLACA. Would you like me to put you in the program, the drug program in the jail, ma'am?
Do you want to do an in-custody program? In-custody drug program? He's going to revoke your bond. Do you want to do a program while you're sitting? Yes, Judge.
Ma'am, I'm going to set your bond at $1,000 today, revoke your bond at 157199 CF10. Can I have a SAP order? Yes. Thank you, ma'am. How about Natasha Oliphant, Delencia Smith, Ashley McKenzie, and Shannon Brown, and Jasmine Brown. Oliphant.
Not at the main.
Okay. Where's Miss Oliphant? Where's Oliphant? Right there? Okay, got it. Ma'am, possession of FLACA. The court finds probable cause. Do we have any priors on Miss Oliphant?
One moment, Judge.
Ma'am, are you currently employed?
No.
Do you have money in the bank?
No.
Just let the judge know, please.
Go ahead, Steve.
Well, she just had like both priors on both three, like trespass and loitering.
Ma'am, do you have a current address you're going to live at?
Yes.
What is that?
2374 Northwest 20th Street,
Okay.
apartment A.
How long have you lived there?
For October,
Who do you live there with?
myself,
And how do you pay your bills there? You told me you don't work. You'd have no money.
my boyfriend.
Okay, ma'am, I'm gonna let your boyfriend bond you out today based on these facts and your criminal record. Your bond's $1,000. Thank you, ma'am.
What is that? Is your house? What's the apartment number?
May I see,
What?
Delencia Smith?
Everybody calm down.
Ms. Smith?
Paul Ryan, Judge.
Possession of PvP, the court finds probable cause. State, do we have any person, Ms. Smith?
Judge, she's at Paul Ryan facility.
Sorry. Where's Delencia Smith?
My bad.
Right here.
There you go. Do you have any person, Ms. Smith?
One moment.
Ma'am, are you currently employed? No. Do you have money in the bank?
No.
How do you support yourself? How do you pay for your food and your housing?
I receive food stamps and cash assistance.
Okay, do you have children?
Yes.
How many?
One.
How old's your child, ma'am?
2.
2 years old, okay. Okay. Go ahead and state, does she have any criminal record? No? Okay. Ma'am, I'm going to release you on your own recognizance today. You have to go to pretrial release downtown Fort Lauderdale tomorrow between 8 and noon. Do you understand that?
Yes, sir.
You're going to have a drug and alcohol evaluation. You'll be tested every week for drugs. If you come back positive from cocaine, flakka, marijuana, anything, you'll be rearrested. Thank you.
I mean,
May I see Ashley
yeah,
McKenzie?
We'll call you then.
North Broward, Judge.
Yes.
Ma'am, possession of PvP and cannabis. Court finds probable cause. Do we have any priors on Miss Ashley McKenzie?
Anything McKenzie? One moment, Judge.
No, Your Honor.
Now, ma'am, do you have a current address?
Yeah.
What is it?
1700 Northwest 6th Place. Fort Lauderdale, Florida. 32301.
Okay. How long have you lived there?
4 years.
Okay, well, I have an address on Northwest 24th Avenue. I have another one on 6th Place.
Yeah, just my mom address. 907 24th.
Ma'am, I'm going to let you bond out for $1,000. Thank you. How about Shannon Brown, Jasmine Brown?
Your Honor, this was up for perfection.
Right.
I provided counsel and Your Honor supplemental reports. They both read the same, but they just have the listed facts that cover both sisters.
Okay. Just give me a moment. I've been given a supplemental report. Which Brown sister do we have at main jail? Who's this?
Judge, this is Shannon Brown.
Shannon Brown, all right. No. Okay, go ahead, state.
All right. Well, there was an issue of identification. I believe that's been resolved, and that both victim and both defendants are personally known to both witness and victim. He's his sister, the witness's sisters, and the victim's brother. They are the sisters of the witness's boyfriend.
The victim's boyfriend is brother to
The
this
victim.
Yes. So they're all personally known to one another. There was no need to do a show up or a photo ID. Two, the explanation, and Deputy French informed me of this yesterday, so I can proffer the explanation for why the language read the same in the reports is because the information he received and the allegations he received is, as far as the battery occurs, is that the conduct was the same, that they both entered the vehicle and were punching the alleged victim. So that's why it read the same. So that's my argument as far as PC. As far as proof evident or presumption great, Your Honor, there's a victim's account that is verified by a witness who is related to the two defendants that advised that they did not have permission to enter his vehicle. They both entered his vehicle without permission, and therein committed a battery against...
They didn't have permission to be in the vehicle.
It says... One moment, Your Honor. In the second paragraph, both Jasmine and Shannon then went inside the vehicle, unlawfully and uninvited, reached across Mr. Brown and punched Ms. Clero multiple times in the face and side of her body with the closed fist.
But how do we know they weren't allowed in their brother's car?
Because it says it, Judge.
Exactly.
It says it was uninvited. Your Honor, it says the officer spoke with the owner of the vehicle,
right,
spoke with Mr. Brown, spoke with Ms. Clero, and it states it. They weren't invited.
Mr. Miller, do you have anything else? Do you have any
Judge, does this say what kind of car this was?
A blue Acura Integra.
The question I have, and wasn't answered between yesterday and today, is how is it that two bodies are alleged to have done the same thing? They're both alleged to have entered through the driver's side door and attacked a woman in the passenger seat. Okay? I don't see how that's possible. This is not a big car that two people could enter the front door at the same time. And something is missing here, Judge, and my argument to the court is that because they haven't delineated who did what, they're still sticking to the same story that both of these women went into the front driver's side door and attacked the passenger in the front seat. That there's no proof evident that this occurred in this way. It may have occurred, but they haven't delineated who did what. They're still sticking to the same story, and I'm arguing that that's not possible.
Okay.
And so, because it's not possible, there is no proof evident or presumption great, and both of these women are entitled to a bond.
Court's going to find probable cause, but not proof evident presumption great on these two women. State,
is the court finding that it is not possible for two people to go in through a front door?
I'm not going to get into all that.
Because I don't see how that's possible.
But I'm not going to find proof evident presumption great. So tell me, neither of these women have.
One moment, Your Honor.
Right?
One moment, Your Honor.
Any information regarding Shannon Brown's ability to bond, sir?
One moment, Judge.
Yeah.
Jasmine, where's Jasmine? Jasmine, are you working at this time?
No, I'm not.
Do you have any money in the bank, ma'am?
No.
How long have you lived down here in South Florida, ma'am?
My whole life.
Okay. Do you have children?
Yes, I have a 2-year-old and I'm pregnant.
Oh, okay. Congratulations. Who's going to help bond you out of jail today, ma'am?
I'm not sure.
Okay, do you have family down here?
I do.
Okay, thank you. What about you? Go ahead, Mr. Miller.
Judge, Ms. Brown, Shannon Brown, is a lifetime resident in South Florida, living at the same address for the past 5 years. She has a job at Global Response. All of her family lives down here. She has no money in the bank or real estate. She's going to have to ask her family to bond her out. Judge, I believe she has no priors. Is that right? State?
Shannon Brown.
Ms. Miller, I'll address the court. I'm not addressing
Do
you.
either one have a criminal record?
Your Honor, I did see Jasmine Brown was arrested for a domestic violence battery last year. That was dropped. I did not see anything for Shannon Brown.
Shannon Brown, I'm going to order you and I'm going to order your sister, Jasmine, not to have any contact directly or indirectly with Audrey Claro. Don't go near her. Stay 500 feet from her at all times. That's where she lives, works, goes to school, anywhere in between. Now, Jasmine Brown, count one, your bond's $3,500 to $500. And Jasmine Brown, that's Shannon Brown, sorry. Jasmine, your bond's $3,500.
Judge, would the court do a med screening in light of,
I'll do med screen on Jasmine. Thank you.
What was this, count 2 for Shannon, Judge?
500. There you go.
All right. Thank you, Judge.
Okay, now let's go Jose Garcia, Terry Jackson, Eric Helton, and Robert Bruni. Line up, please. Jose Garcia.
Judge, Mr. Garcia is present at the Maine. He would like to resolve this case if the court is so inclined. Could you switch thoughts with him?
Can I hold on to this?
I asked the judge if you can resolve it. Now he's considering it, and he'll let us know.
Listen, can I hold on to this so I don't fall? My leg. Thank you.
One moment, Your Honor.
Yeah. Garcia, you're charged with resisting arrest.
Yeah, we're going to oppose resolving it based
I agree.
on his
I'm inclined to.
unlawful use of false name identity 08. All his other cases are under the name Jose Quirindongo. Possession of cocaine, Carasperodol, drug paraphernalia 07. Contributing to the delinquency of a minor 07. Possession of oxycodone 07. End of record.
Got it, sir. You can bond out. Your bond's $100. Good luck. How about Terry Jackson?
Thank you. Judge, he's present at the Maine. It's my understanding that the bond has been posted for Mr. Jackson.
Probable cause is found. Your bond's been posted. Your bond's $350. Thank you, Eric Helton.
All right, good luck. Judge is present at the Maine. He was present at the Maine. Are you Eric?
No. Eric Helton.
Helton.
I think he might be in North for some reason.
He should be.
These are MI capuses. No. Judge Lerner Wren.
You know where Judge, Mr. Helton is a medical reset. We would ask the court for
I'm going to leave it no bond. Let it go right to Judge Lerner Wren. How about Robert Bruni?
Judge, could you order a mental health screen for Mr. Helton, please?
Well, he's going to mental health court. He's heading to Lerner Wren anyway. All right?
Right, but I want to make sure he's receiving proper care while he's in custody, Judge.
Bruni is bonded. Okay, I'm going to order a mental health screen for the last gentleman we had, Helton.
Thank you, Judge. Okay, you're bonded. Fillmore.
No, I know what I'm saying is in
Marcel Fillmore? Huh?
Marcel Fillmore, Stephen Flowers, Vernon Coleman, and Steve.
Okay,
Bjornsson.
one moment, Judge.
No, he's back. Bjornsson.
he's in the hospital. Long
Marcel Fillmore.
We're working on it, Judge.
Okay.
Flowers.
We got him locked in. All right, they're going to get him, Judge. You want to go to the next one?
Okay, what about Flowers? Do you have Flowers in the jail?
Stephen Flowers? This is Mr. Flowers, Judge.
Posted, sir. Your bond's posted.
Here you go. Good luck.
How about Vernon Coleman?
That's me.
This is Mr. Coleman, Judge.
Sir,
Mr. Coleman is
trespasser.
interested in resolving the case.
Mr. Coleman, would you like to resolve your case? Plead no contest.
Yes.
All right,
Yes.
sir. Court finds probable cause. Discharge. Refuse to leave the hospital. He was there just a couple days before. He wouldn't leave this a couple days before. All right, how do you plead, Mr. Coleman?
No contest.
You understand we're not going to have a trial. The case will be over with right now?
Yes, yes.
Okay, I'll withhold adjudication. Good luck. Thank you. How about Steve Kobjortson?
Judge, it's showing that he's on loan, medical loan. However, I reviewed Odyssey today. The capias in this case issued on May 28th. Mr. Kobjortson was in custody from May 5th until June 11th.
So I'm going to release him on his own recognizance today on this charge. Thank you.
Thank you, Judge.
Yeah, he's going to issue no contact,
Hold on
but
one
everything's
moment.
done.
Herbert McLeod,
You want to notice that?
Daniel Alexandre, Charles McIntyre, and Ernest Butler.
Judge, we have Mr. McLeod and Mr. Fillmore is in the courtroom now.
All right, Mr. McLeod, 2 counts of violating probation, no bond on each one. How about...
Judge, can we get a life skills order for Mr. McLeod?
I don't know, I've never done that before. Give it a
It's
sign.
the same as SAP. It just says SAP. It's life skills instead of
Okay,
SAP.
I'll sign that. How about
Thank you,
Marcel
Judge.
Fillmore?
Mr. Fillmore is present at the main.
Marcel Fillmore.
Sir.
Sir, you got a warrant for no valid driver's license, sir.
Yes, sir. Did you want to try to resolve this? Any
Sir,
chance of resolving this one, Judge?
Sir, I'm going to let you bond out. You need to go to bond out $100. Thank you. How about Vanel Alexandre?
Okay, off you go. Main jail.
Aggravated battery with a deadly weapon. The court finds probable cause. Are there any priors on this gentleman?
One moment, Judge. Yeah.
Good.
The only thing I see, Your Honor,
struck by the defendant on the head with unknown type of glass bottle without provocation. He did not know the defendant personally. Other patrons on scene told him the defendant's name. He had a 2-inch long gash about an inch deep.
No priors, Judge.
So what do you do for work right now? Mr. Alexandre, what do you do for work?
A guy slapped me and
Where do you work?
I work U-Pull-It, junkyard.
You work at the U-Pull-It?
Yeah, junkyard.
Salvage yard?
Yes.
What do you do there?
For 41 Griffin Road.
What do you do?
He does work in the tire machine.
Okay, do you have any money in the bank?
Little bit.
A little bit?
Yeah.
Do you have someone to bond you out?
Yes.
Who are you
My
going to call?
wife.
Your wife?
I got my wife, I got kids.
How long you been here?
14 years.
14 years?
Yeah.
Anything else, Joe?
Sir, no, that's it. I'm going to set your bond based on the level of violence. Court's concerned for the safety of the alleged victim at $5,000. No contact with Lucina Vaxamere, directly or indirectly. Thank you. How about Charles McIntyre?
President, the main judge, he declined the PD. I believe Mr. McIntyre also would like to go to this life skills program.
Violation of probation, no bond. Let's put another. Okay, we'll put him in life skills.
Thank you, Judge.
I need some.
Ernest Butler.
Thank you, sir. Thank you.
All right, Ernest
Devon,
Butler.
medical reset. Devon.
Okay.
Yeah.
Yes, sir.
Excuse me.
How are you? I just wanted to hear you say it.
Ryan Pierre, Devon Singletary, and Gene Altenor.
Ryan Pierre, bonded, Judge.
Pierre?
Yeah, med reset.
Bonded. How about Devon Singletary?
President Domain.
Sir, grand theft auto, resisting arrest, disobeying a stop sign. Court finds probable cause. Allegedly driving a. Okay. Jumped out of the driver's seat and fled through in between houses. All right.
Judge, I do have an argument with regard to the grand theft auto.
Go ahead, sir.
It would appear from this police report that the vehicle in question was reported stolen after this man was arrested. If you'll notice the police report, stolen vehicle case 11-1506-005326.
Right.
This is case number, offense report 1506-4340. It follows logically that 5326 comes after 4340. So I would argue that the vehicle was not reported stolen prior to him being arrested.
Your Honor, if I may, and I'm guessing I'm a little more knowledgeable about this issue. The offense report number is from a Lauderhill Police Department. The stolen vehicle case number is from BSO. They're two completely different agencies that use different ways of entering numbers into their system. This alleges that it was reported stolen on June 19th, and this incident occurred June 22nd.
Right. Okay, well, sir, I'm going to let you bond out today. Your bond's $1,000. Thank you.
All right, good luck.
How about Gene Altenor?
Judge, Mr. Altenor is president of Maine. He has declined the public defender. He indicated that his family is going to try to hire a private counsel for him. I wonder if the court would consider resetting this for tomorrow afternoon to give them an opportunity to do that.
So I'm going to do this. I'm going to reset this for tomorrow afternoon, tomorrow p.m. Sir, contact your family. Have them come to room 235. Have the attorney come to room 235 if your family wants to be here tomorrow. That's great. 235 tomorrow at 1:30. Thank you.
All right, thank you. Good luck. See you tomorrow. I haven't talked to you no more? Talk to you? I'm busy right now. Patterson?
William DePadua, Arejo, Scott Kramer, Nicanor Farfan, and Anthony Allen.
Is Anna there?
William is at North Broward, Judge.
Could you just ask her? Call 0649 when she gets back, please.
William DePadua Arajo.
Yes, Your Honor.
You're charged with battery, disorderly conduct, brawling, fighting, disorderly conduct, breach of the peace, obstruction of traffic, corruption by threat. Court finds probable cause. State, do we have any criminal record on this defendant?
Patrice, do you have anything?
No, sir. This is my first arrest.
I understand. This is first arrest. Ever. Ever.
Ever.
Okay. Anywhere.
Yes, sir.
Go ahead. No, ma'am. He just told us he did not, he's never been arrested. This is William DePadua Arajo.
He might mean as an adult.
No.
I know, I'm just saying he might have meant as an adult.
Patrice, excuse me. The gentleman just said he's never been arrested anytime, anywhere.
Anytime, anywhere. So being a boy. He was only 18. He was barely an adult.
Okay.
Well,
So,
that's a matter of
are you saying that he has been arrested?
like
A few times.
there's been some juvenile stuff, but they've been dropped.
Okay, well. Okay, now, sir, are you currently employed?
Yes, sir.
What do you do for work?
I'm a barista at Starbucks. I work full time, and I'm a good kid. I really am.
Do you have any money in the bank, sir?
Yes, I do.
How much do you have in the bank?
$1,500.
Do you have family down here in South Florida, sir?
I have a father that lives here.
Okay. So I'm gonna set your bond on count 1 at $1,000, 2 and 3 at $25, and I'm gonna set count 4 at $1,000 for allegedly threatening the police. Your total bond's $2,050.
No victim contact, Judge?
No contact with either victim, sir, directly or indirectly. That is Michael Cheek. No direct contact with him. Thank you.
Okay, thank you, Your Honor.
Yes, sir. Scott Kramer.
Main jail.
Mr. Kramer, possession of cocaine, alprazolam, drug paraphernalia. Court finds probable cause, sir. Count 1, 2, 1,000, 3, 100, 4, 5, and 6. You have a warrant on 4, no bond. Violating probation, no bond on 5. Count 6. Misdemeanor warrant, 1,000. Thank you. How about Nicanor Farfan?
What is it, Canal
Anthony Allen.
3,100. Off you go. Who are we looking for, Judge?
Farfan.
He's gone.
President of the Maine declined PD.
Sir, your bond has been posted for
No, I think
license
it's not very
suspended.
well,
Thank
but
you. You're
I'm
out of
fine.
jail soon.
Your bond's been posted. You'll be
Anthony
out
Allen.
soon.
What?
Your bond has been posted.
Anthony Allen.
No, he's present.
Is that you?
Anthony Spranzo. Mr. Allen,
Anthony Allen.
can you come over this way? Judge wants to see you.
Excuse me. So you've been charged with 2 violations of probation. They're both no bond. Thank you.
All right, you're going to see the judge on Monday. You're going to see the judge on Monday. This is Mr. Cropper, Judge. He declined PD.
Who's this?
Oh, Robert Cropper.
Right out. I might not even, I might just stop at like 7-Eleven, I don't know. I sympathize. I mean, 2 I'm running now, and it's not. Well, yeah, exponentially, sure. Yeah.
I know, believe me, I know. Marge. All right, Robert Cropper.
Yes, Judge.
Sir, possession of cocaine. The court finds probable cause. Do we have any priors on Mr. Robert Cropper?
2008 felony DUI, DWS permanent revocation, refusal to submit to testing. 2013 possession of cocaine, 85 possession of cocaine. That's just Broward.
How was he permanently revoked?
I'd have to check.
Judge, he wasn't driving.
A white male walking around the entrance to Paradise Village taking his clothes off at around 3 o'clock in the morning. Wearing just his underwear, heavily intoxicated.
He didn't have to go far for his wallet.
Cocaine, total weight, 0.5 grams in a baggie. Cropper, what do you do for work?
Construction, Judge.
Okay.
All right, are you currently employed?
Yes.
Do you have any money in the bank?
I have some.
Do you have family down here in South Florida?
Yes, Judge.
Who do you have?
I have all my family.
Okay.
Mother, father, brother, sister.
His license was permanently revoked in 1998 from being convicted of 5 DUIs between 1982 and 1998. Also had a possession of controlled substance out of California in 95.
Okay, sir. You got 5 DUI convictions, and now you're intoxicated. They found cocaine in your wallet. Apparently, you've had a
I'm sorry.
lifetime issue with substance and alcohol. Go ahead.
He's got a total of 6 DUIs.
6
The
DUIs.
reason the 6 DUI didn't make it on his driving record is because it looks like he was convicted out of circuit court, and they probably didn't inform THSMB properly.
So I'm going to raise your bond today to $2,500. I'm going to let you bond out of jail based on your criminal record. That's the case. Thank you.
What about the phone?
Judge, he needs an order allowing him to use a phone. They haven't given him a phone call
Thank you.
yet.
Sean Shaw.
That's it.
Sean Shaw.
See that?
Sir, possession of heroin. Court finds probable cause. Do we have any priors on this gentleman?
Patrice, do you have any notes on him?
Your Honor, if I could ask you.
What year was that? 2006? Got it.
He's got a lot. Oh, wow.
Okay.
Judge, would the court sign an order to allow the public defender to take photographs? I see him in a cast.
Let's find out. Okay, anything else? Sir, how long have you lived down here in South Florida?
My whole life, 29 years.
Are you currently employed?
I do side work. I do roofing, but it's not on the books.
Do you have money in the bank?
No, sir, I don't.
Who's going to help bond you out today?
I don't know. That's why I was asking if I could
She's
get.
not going to stop.
I need to get it back into the hospital to get my wounds taken care of. Also, if you could ROR me,
Say that
I'll be
again.
back at the.
Okay.
Casey. And Judge, just to let you know,
Go ahead.
the only reason he's before you is because the hospital deemed him, medically ready to be discharged from the hospital. He was there. And that's why it's been reset. So, I mean,
Okay, sir. Sir, let me.
Right, And now I also have something else coming on my leg that I need to get taken care of at the hospital.
Right,
and-
so you're saying you need to get out of the jail, right?
Yes, sir.
Yeah, well, that'll happen once you post your bond. I'm not gonna send you out. Sir, you're 29 years old. You've been convicted of either selling or possessing cocaine 1, 2, 3, 4 times, a heroin, 2 license suspended. You've gone to prison in the past, and now you're allegedly with heroin again. So I'm gonna set your bond today at $5,000. And you can bond out based on your criminal record, the facts of the case. Thank you. Hakeem Morgan.
I feel for him.
Why did you raise the bond?
Someone, ooh boy. Do I need to explain it to you? Hakeem Morgan. All right, Hakeem Morgan.
They're professionals. They know. Like they
robbery with a firearm.
You know.
And I think that's been changed now to.
Exactly. So, it's Your Honor. The first when it came through over the weekend, they didn't have the affidavit. So, Judge, it should be attached.
I was gonna make argument on the case, Judge.
Just give me a moment. I need to read this real quick. Hakeem Morgan, you're here for armed robbery, and we're here to determine whether there's proof evident presumption greats. I guess you are seeking to foreclose bond and release conditions, right, State?
Yes, Your Honor.
All right, go ahead, State. Tell us why you think there's proof evident presumption great today.
Your Honor, so I was trying to call you. It got reset for tomorrow. He's going to hire an attorney. Your Honor, just relying upon the sworn statement given by the alleged victim that the robbery occurred, that the defendant was in possession of a black semi-automatic pistol at the time, that the defendant demanded the victim's money and cell phone, which the victim gave to the defendant, that the victim gave a specific description, Your Honor, of the defendant. Then the police receiving information from an anonymous source, receiving information about physical description which matches the physical description given by the alleged victim. At that point, leading to the police getting identifying the defendant, getting a picture of him, and then through a double-blind photo array, the victim identified Mr. Morgan as the person that committed the armed robbery of him at the Wells Fargo Bank in Hollywood.
May I respond, Your Honor? Judge, I note that the incident occurred on May 30th, 2015. If you look, Judge Williams signed a warrant on June 11th. Nothing in the probable cause, not in the warrant for Mr. Mr. Morgan's arrest indicates when the photo lineup took place. Was it done close to the incident? Was it done 10 days after the incident? It doesn't say if he was identified 100% and as to what certainty he was identified by the victim in the case. And I also have issues with the anonymous source. Anonymous source, so if we're talking about proof evident presumption great, from my understanding, would not be admissible in court. There was no indication in the probable cause in the warrant for arrest that the victim's money
Well,
or
let me just stop you right there. As far as the anonymous source goes, the anonymous source to me, in this court's opinion, is collateral to the entire story. Whether it was anonymous source or known source, they didn't really provide any. They basically said, "Hey, I heard a rumor that this guy could be the one." I don't give it any weight. I'm looking at, other than what that source said, does it meet that level? I don't give any credence to the anonymous source.
Well,
The anonymous source didn't really provide anything other than a rumor, and that got the police on the trail of the guy. But other than that,
I think the bigger issue is this, Judge. There's no indication in the warrant for arrest when the photographic when that lineup was presented to the victim in the case. I think when you're talking about eyewitness identification can be one of the most unreliable sources of identifying somebody. There's nothing in here that will concretely tie this incident to Mr. Morgan other than a description or an ID. There's nothing in here that would say that this is 100% the person that robbed me. And we're talking about an incident that took place on May 30th. No indication in the warrant when the lineup took place. Now, I think that's very important for the court to consider, because if it took place within an hour, within the same day of the incident, the court can give it greater weight. We don't know that from the warrant to arrest. Based on those circumstances, I don't think that the allegations in the warrant rises to the level of proof evident presumption grade.
got it. Steve.
I think what is relevant about the information provided by the anonymous source is the description, because the description that was given identically or not matches the description given by the alleged victim. I think it adds credibility, Your Honor. Additionally, in that is the person, the person that was whose identity was provided by the. If all we had here was the anonymous source, that'd be one thing, but that the information given by the anonymous source, that person happened to be identified in a double-blind lineup. The officer involved in the case was not present when the victim made the identification, and they identified the same person, Your Honor. This is the issue we get into in here, Your Honor. This is not an adversarial hearing. It's to be based on what is before the court. To say that, well, photo IDs they're just unreliable. Well, then that means any case where there's a photo ID, there's not going to be proof evident presumption grade. To say that, well, because it happened 2 months, a month, it can't be. These are the things, Your Honor, that I think evidence can come out of at an adversarial hearing, an evidentiary hearing. And that's the whole purpose of an Arthur hearing. For today's purposes, is there any flaw in the evidence provided to the court? Is there any indication, there's nothing to indicate that the victim equivocated, that there's an indication that somebody else could have done this, Your Honor. There's no indication that maybe he didn't have property stolen from him, that it wasn't a firearm, it could have been a toy. And that's why I think based on the evidence in the affidavit, Your Honor, there is proof evidence.
Did they recover a firearm?
He found.
Court will not find proof evident presumption grade.
How long have you?
Adopts. Well, the court agrees with the argument made by Mr. Offsell that that there are some issues about identification. Namely, when was this lineup taken?
Well, it says when it was taken.
Does it?
Yes, Your Honor.
What was the date?
May 30th. One moment. Actually, wait, let me just wait. Okay.
I think Mr. Miller would like to add. I don't know. I don't want to speak for
We're
anything.
not going to find proof evident
Well,
presumption great.
Your Honor.
The court is concerned that just based on the totality of the circumstance, it does not rise to the level where the court is comfortable precluding or excluding any bond conditions, release conditions based on this evidence. State, does he have priors?
Well, Your Honor, then I would ask, Judge Luzzo found PC. He was informed of his priors. He found, and he set a bond, just like the case we had the other day on the sex offense, where Judge Luzzo set the bonds.
I'm leaving the bond at $500,000. I don't believe you represent a danger to the community in any way. Judge Luzzo already reached that conclusion. Thank you. How about Matthew Patterson? Distributing methamphetamine, sir. Court finds probable cause, possession of cannabis. Go ahead, state. Are there priors on this gentleman?
One moment, Judge. Priors include burglary conveyance 2013 VOP.
Got it. Sir, are you currently employed?
Yes.
What type of work do you do?
I do timeshare sales for Capital Resorts at Hollywood Beach Tower.
Yes. Burglary structures open? What's the case number?
With Palm Beach.
Palm Beach. Burg structure, and what was grand theft? Okay, sir, I've just been informed you have an open burglary and grand theft out of West Palm. I'm gonna go ahead and set your bond on count 1 today at $2,500 based on your criminal record. The facts of the case, thank you.
Judge, we also have one other matter on the docket, the carrying concealed firearm case, the 76-year-old gentleman from this morning.
Albert Benjamin.
And I did have an opportunity. To speak with him, Judge. There's one thing he gave me permission in terms of his medical condition. I like to say to the court, but I don't want to say it. On the record.
Okay, you probably don't need to. I'll just take your word for it. Serious medical condition. Let me ask you, where is he?
He's currently at the North Broward Jail, Judge. Yes.
Hey, Mr. Benjamin.
And Judge, I would also ask the court to allow the public defender to take photographs of his injury.
I've read the case. I'm going to find there is probable cause for carrying concealed firearm. But let me ask you, sir, does he have any criminal record?
One moment, Judge.
Mr. Benjamin,
not really.
Mr. Benjamin, if I let you out of jail today, you're going to promise me you will not have a gun or a firearm in your possession while you're out on release?
No.
Wait. Are you saying you promise you're not going to have any guns or any weapons in your possession while you're out?
No.
No,
no,
what?
no, yeah. No guns, no nothing while I'm out.
Good. All right. Steve, do you have any?
There's a lot of stuff here out of Illinois. I'm just trying to figure out. Great. Looks like he had a firearm offense in Illinois in 2001.
Right.
Another firearm offense. Wait. No, never mind.
Wasn't that an Illinois offense dropped?
I don't know, but
No.
Go ahead.
It wasn't.
What else do you have?
There was more than one, but I wasn't going to bring that up. Another firearm offense. That was from the 80s.
So I'm going to release you on your own recognizance today, all right? Thank you.
State objection, Your Honor.
Thank you, sir. All right, Your Honor.
All right. Now,
Okay.
how about,
Judge, there is a gentleman at North Broward. I understand it's a municipal ordinance case. I don't see Mr. Adri here. I understand that I don't have standing here, but I used to represent him in mental health court.
Right.
He had a VOP, and there's municipal, only thing holding him is a municipal ordinance case. He was committed to this, I just want to say this, that he was committed to the state forensic facility.
Right.
He was placed on probation. I know that he has more than like 600, 700 days in the Broward County Jail, and I don't think he has, I think other than the case that he was on probation for, he doesn't have many priors or anything in the past of a violent nature, and the only thing holding him is this municipal ordinance case.
Okay. All right. What's his name?
Anthony Speranzo.
I thought they resolved that.
No, because the judge didn't have his paperwork. Then Drew left, and I was hoping, I told him what was going on. I was hoping he could resolve the case for him. And Judge, I apologize. They already have a place for him to go. Broward Outreach Center has a bed available for him.
You ready?
Mr. Speranzo, have a seat. We'll be back with you in a moment.
What's that? Just start scanning now.
He would have told you. No, he's locked up back there. He told you, but
Yep, if I have to.
bring him back in or wait till you get finished? I'll bring him back in. It looks like.
I'm not thinking about 6. I'm thinking about.
Say, what about Lawrence McCray? What did you do on that? You are Lawrence. Did I?
You already are awarded.
Okay. Okay, what about, may I see Nicholas Cipriano?
Paul Ryan.
Good afternoon, Your Honor.
Hi, sir, you're here for violating an injunction. I'm gonna send that right back over to...
No. This is a 30-day, Your Honor. Yeah, we declined this charge because we filed the allegations in this case as part of a felony aggravated stalking. So he can be ROR'd on this case number. He's still going to be held no bond on another case number.
Court order for me to ROR him on this? On Cipriano, it's a misdemeanor. Cipriano. Thank you, sir. I'm going to release your ROR on this charge, all right?
And the second charge that pertains to the other one, does that have anything to do here or have to come back?
No, it has to go back to your other judge, all right?
All right, thank you, Your Honor.
Yes, sir. Where do we mark ROR on here?
Come back 2 hours. I'm not gonna say a word.
I understand.
I get it.
What do you want? There's no bathroom. I got to find somebody to take you.
What about,
I leave myself.
how about Darren Thomas? Darren Thomas.
I only one time. I'm not retarded. I know, ma'am. And you repeat it over and over again.
Thomas is president. The main judge is here for a second look. It's a trespass with a $100 bond. How long you been in custody?
Darren, would
Have
you
a
like,
second, Judge.
Darren, would you like to plead no contest to this?
Your Honor.
He's going back to what? What's he-
I don't know. Let's check it out and see before.
He's going back to a gas station.
All right.
Speedway gas station, harassing customers. So would you like to resolve this today?
Lucky customers.
You want to resolve this today? Yes, sir.
So if you plead no contest, case is over with, we're not gonna have a trial, and you're gonna agree that you're not gonna go back to the Speedway gas station, all right?
Mm-hmm.
Is that clear? How do you plead, sir?
No contest, sir.
Okay, I'm gonna accept that, and I'll withhold adjudication. Good luck, sir. Thank you. How about Frank Simeon?
Down the middle. Out the door. You want to go home. Simeon,
Frank Simeon?
present at the main.
Mr. Simeon, theft, sir. Hold on a moment.
Raise his bond.
What's your question?
Not to be an odyssey. I can tell you what the allegations are. He stole 3 steel reserve cans from a cooler. Do you have a Casey? Do you have a copy of the judge's findings?
1 second.
You don't, Simeon?
No, sir.
That's great.
Where did he steal it from, do we know?
I don't know.
How long has he been in jail? 6 days? Simeon, would you like to resolve this today? Plead no contest, case is over with today?
Yes, I would.
How do you plead, sir?
No contest.
Okay, I'll accept that. I'll withhold adjudication. Thank you. What about Jennifer Davis?
Well, Your Honor,
what do you want?
I'm presently homeless.
Paul Ryan.
Hello,
Your Honor.
Said he's homeless.
Okay. All right, well, good luck, sir, all right? Thank you. All right, what about Jennifer Davis? Hi, Miss Davis,
Yes, sir,
you're
Your
here
Honor.
for theft. You've been in jail 6 days. Hold on.
She was out on something.
Miss Davis allegedly stole from...
No, but you raised her bond to 1,000 because she was arrested May 13th for
Right, I remember.
theft and cocaine and
Ma'am, I'm
prize
gonna send this to
impounding.
your division judge. All right, thank you. How about Kevin Navander? Kevin Navander.
Yes.
Mr. Navander, you're here for prowling, loitering. Court finds, let me see here.
He was trying to. He's trying to get into people's car doors, people's cars at the Broward General Hospital parking garage.
Was he?
That's what it says.
Okay, I don't think he came in under me. I would've remembered that.
When he tried hiding, then he revealed himself and stated he was checking the cars for the owner of the garage. He stated he was going to move cars to make room on the ground floor. When I advised him it was a self-parking garage, he could not answer why he was there.
Okay. I see right here, he's been here for a couple of years. Does he have a criminal record?
From what I can tell written here, in 2008, uttering a forged instrument, 08 trespass. I know the assistant state attorney has limited access to priors over the weekend, so I couldn't tell you what else there might be.
The defendant was trying initially a Dodge pickup truck, then he was trying other door handles when they saw him the second time. Right. The defendant kneeled behind a red four-door car and attempted to conceal himself in the afternoon.
Yes.
All right, so he's been in jail now 5 days. Sir, would you like to resolve your case today?
Yes, but I was just trying to make room in the garage with a friend of mine.
Sure.
By trying everyone's cars.
Sure. If that's your story and you're sticking to it, Mr. Nevander, then that's your right as an American. Would you like to resolve your case today?
Yes, if I could.
Okay, do you understand that we're not going to have a trial, we're not going to put an attorney, the case is over with right now? Do you understand that?
Yes, sir.
How do you plead to this charge, sir?
No contest.
Okay, I'm going to order you don't return to the parking garage at the Broward General Hospital, all right? Or any of the parking lots around the hospital. Thank you. Miranda Morehart.
Okay, there you go. You're done.
Okay.
Just checking the doors. All right, what about, and that's why. Okay, Miranda Morehart. Do we have Miranda? No? Okay, what about John Booth? John, is this on? Yeah, it's on. Okay, we'll go to the next one. How about Sean Charlton?
My name's John Avery Booth. Mr. Booth is present at the main, Judge.
Jeez, I think you just found Booth.
Okay.
I've been here all day.
All right, trespassing, sir.
Just not called my name.
Yeah, well, I called there a couple times. All right, on that note, hold on there, Mr. Booth. Get to you.
Sorry.
Mr. Booth, you're arrested for trespassing. 2 counts. Let me just see what they say you did here.
Right, Mr. Patterson is in jail.
7-Eleven.
Yes, if you could please bond him.
5 minutes white male who's drunk and harassing customers. Allegedly late in the evening. Okay? Got it.
Yes, sir.
Would you like to resolve your case today?
Yes, sir.
Sir, I'm going to ask you, as a part of our resolution today, you don't return to that 7-Eleven on Griffin Road, all right?
Correct.
No, sir, I won't. I remember it being a mobile gas station.
Well, see, you've been drinking a lot that night, sir.
Well, one of the ladies that worked there, she had 7-Eleven wrote on her tag, and I told her, I said, this is a mobile gas station.
Well, that's probably part of the problem, sir. When you drink that much, you can't tell the difference between a mobile gas station and a 7-Eleven. That's probably part of the problem, or that may be the result of the problem. But that being said, would you like to plead no contest?
Yes, sir, I'll plead no contest.
Well, you know, the mobile gas station's just a block down on the other side of the street, so. All right, do you understand you're not allowed to go back to that 7-Eleven, sir?
Yes, sir, if I had $1,000 million, I would not go back there.
$1,000 million, well.
I would not go back there.
Well, I know, and if you ever get that kind of money, let me know. $1,000 million. All right, now, how do you plead, sir?
How do you plead?
No contest.
All right, I'm going to accept that. I'm going to withhold adjudication. Thank you, Mr. Booth.
Thank you, Judge. Okay, Mr. Booth, down the middle, out the door.
Does that mean I'm out of here tonight?
You're out of here tonight.
Thank you, Your Honor. I mean, not Your Honor.
Not yet.
Yeah, Your Honor.
A public defender.
Thank you.
Thank you, too, Your Honor.
Oh, you're welcome, Mr. Booth. Anything we can do to help. All right, now,
Okay.
where's Sean Charlton?
Present at the main, Judge. He is also interested in pleading this out.
Okay. Been in jail 5 days. How come you haven't bought it out yet?
I don't have the money, Your Honor.
All right, sir. Well, I read the allegation against you. Would you like to
You know how
resolve?
it goes.
Would you like to resolve your case today, sir?
Yes, sir.
Sir, how do you plead to this charge?
No contest.
You understand we're not going to have a trial. The case will be over with today.
Yes, sir.
Okay, I'll withhold adjudication, sir. Thank you.
Judge Hurley, can I say something?
Sure. What is it, sir?
I stopped doing drugs. I'm 1 month clean. I got out of, remember you told me to get out of downtown?
Right.
Exactly. So, like, what are they supposed
Got
to do?
out of downtown and went to the beach. Everything's been good.
Well, except when you got arrested with the woman the other night.
Yeah, I know, except for that.
Except for that, everything's been just really great.
Better.
And, so you took my word. Get out of the downtown area. It's not good, right?
Yeah.
Too much bad stuff goes on that whole downtown.
You're right.
Yeah. Well, it seems like you're moving on to bigger and, unusual things, sir.
I love you.
Well, thank you, sir. Tell Mr. Miller that, all right?
All right, I heard. I think we're clear at the main. Thank you, Judge. See you tomorrow.
Take care.
Let me tell you, if you ever check the membership of the fan club,
Yeah. Well, see, that man took my wise advice, and look what, he's turning his life around. He's only getting arrested on the beach now. All right, where's Serlina Rivera? Miss Rivera? Man, you've
Hi,
been
Your
in
Honor,
jail.
how are you?
Hi, good. You've been in jail several days for DUI. How come you haven't bonded out of the jail yet, man?
Because I don't
Yes,
have the
ma'am.
money to bond out.
Okay, well,
hold on.
do you have family down here, Miss Rivera?
No, I do not. I came on vacation and I
What am I
liked it
looking
so
for?
much I moved down here.
Oh, how long have you been down here, man?
Almost 7 years.
And are you currently employed?
I work at Dunkin' Donuts.
You what?
I work at Dunkin' Donuts.
Okay, and, all right, ma'am, just let me look here.
Wait, Patrice, are you trying to tell me something about this case?
What do you do at Dunkin' Donuts, ma'am?
I'm a cashier.
Okay, do you get to eat the donuts free now?
No.
No, we do not get to eat the donuts free, sir.
No?
We have to pay for them.
Do you? Okay.
Well, we get to have one free a day. Just
One
one.
free a day.
Yes.
All right, there you go. What's your favorite one, man?
It's the.
The chocolate glazed.
Okay.
How about the
Now,
it's
ma'am,
time to go home
that was
donuts?
just, small talk while we're trying to figure out what happened here. I set your bond on count one at $5,000, two at $2,500, three at $1,500. I gave you a total bond.
And
of
sir,
$9,000.
excuse,
Let me
may I say
finish.
something?
I'm
I knew she
reviewing.
had stuff.
You have an open DUI case right now out of North
The
Carolina.
weird place. Like, I can't tell you how many times.
I
I'll
took
just be
care of
sitting
that,
here.
sir. And then I want to charge
No.
that said that I had a minor up under the age of 18 in the car. No one was in the car with me.
It was her breath. It was her breath, Your Honor. It wasn't the.
Oh. Oh, okay.
Yeah. She said she resolved it, but the system doesn't indicate that.
Well, even if it got resolved or didn't get resolved.
It's still recent. I mean,
DUI last year. Hold on, let me look at something.
An alcohol-related offense in 2012 in North Carolina.
Really?
Yeah, she had a disorderly intoxication. I know she can roll her eyes, but you know,
Yeah,
all she wants.
man,
But
we write all this stuff down and we make notes of it. I see North Carolina.
but she created this situation.
Disorderly intoxication.
Yes, I did.
You're trespassing. I mean, how long have you been down here in South Florida?
Almost 7 years. I go back to visit my children and my grandbabies, and then I come back.
Okay.
Just for the holidays.
I understand. Well, she's in jail for this amount of
That's
time.
a
I don't
very
think she's
a
gonna
lot
be
of
fined.
that's a lot of limited amount
Okay,
of time.
ma'am, what I'm gonna do is I'm gonna release you today on your own recognizance. I'm gonna order that you court to pretrial release tomorrow morning in
Don't push me,
downtown
I don't
Fort
want it.
Lauderdale between 8 and noon time. They're gonna give you a map right there. Ma'am, you only have 10 days from the date of your arrest. Do you have a Florida driver's license?
No, I do not.
Okay, well, you only have 10 days from the date of your arrest to get a temporary driving permit. I don't quite know how that works. You may still want to go out to DMV and talk to them.
I don't think she's getting one, but
So no alcohol consumption while you're out, all right, ma'am?
Yes, sir. Thank you.
Ma'am, good luck. Thank you. Did she say chocolate frosted? No, chocolate glaze. Chocolate glaze. Well, same thing. No, it's not.
are we done? What else do we have?
So we have Robert Jackus. Where's Robert
That's
Jackus?
an MO. I thought that was.
Copy, Your Honor.
Consumption of alcohol in public. Why is he?
It's an MO and because Mr. Jackus is here all the time. Yeah. What? Are you talking to me? I can't hear you. I don't have to, but I will. It's not my fault.
I think I signed it.
Sure you did?
He was never assigned one per Odyssey.
Jacobs. Did I assign an attorney for you the last time you came through here?
No, sir, you didn't.
I did not.
No, sir, you didn't. No, sir.
Judge, when did this
Thank you,
happen?
Judge, it was Judge McHugh. Oh.
Hold on. I know. You know, if you want to jump in and represent the guy, then that's fine. But I know. Okay, go ahead.
No, I'm just curious when I don't have anything that says anything about this case. I'm just noticing.
I know he's been in here a bunch, but so he came through on Judge McHugh. He didn't get an attorney appointed. Okay.
No, sir.
No. Okay. Well, we'll work that out. Let me ask you this.
I do have an attorney now. The public defender office is going to represent me. I just got her the other day.
On this?
No, this is a disorderly intoxication.
Yeah, the reason he didn't have anyone appointed, Your Honor, is it looks like.
Was this split?
No, well, I'm not. None of this makes sense. It looks like.
I'm gonna give him an attorney if he can't afford it.
Oh, absolutely, you should.
Sir, are you currently employed?
Yes, sir, but it's just pennies, not a full-time job.
Well, do you have any money in the bank?
No, sir, I do not.
Do you have
Discharge it.
Do you have
No,
land
sir.
or property?
No, sir, I do not.
Do you have any funds available to hire an attorney?
No, sir, I do not.
Okay, so I'll appoint Steve Shea to represent you.
Excuse me, Your Honor.
Yes, sir.
This case here is a capias, or should be a capias.
No.
For not a, no?
No, he's not even being, technically, he's not being held on this. Here's what happened. This case before you was an NTA, it looks like. He was arrested June 9th. He was arrested June 9th on a state charge of disorderly intoxication. How this ended up on the docket, I don't know. That's why this is a North Satellite case. It would have never been a North Satellite case. As long as he's in custody, they'll automatically That's why it doesn't make sense. But I have no objection to. Obviously, it should be. And Your Honor, if you want to order that this case be assigned to. Here, I'll tell you right now who his other case is assigned to. Judge Evans. Well, he's got this case and another case in front of Judge Fry that's open. And then he's got a case. Do you understand what's happening here? He was arrested June 9th for a state charge of disorderly intoxication. The case that's in front of us today was a municipal ordinance NTA. That's why I got a sign that has a 28 case number. He's not even being held on this. The city filed charges, and I guess somebody at the jail or somebody noticed, and so put him on the docket.
So you mean this is like an ROR situation?
It's not even an ROR. He's not even being held on this. Technically,
He'll get capias because they won't transfer it.
well, that's what I'm saying. If you just order both cases, this case to go to Judge Evans and that it follow the other case, they'll stay together. For the record, the other case being 156274 MM10A.
I'm going to go ahead and
Or you can just resolve.
I'm going to appoint Steve Shade on this, and then is there any way we can have this case on Mr. Jackins go straight to Judge Evans? Can we do that? Transfer to Judge Evans? I'm telling Shade this right now. Got it. Okay, so thank you, sir. I appointed an attorney for you on this. Thank you. What about
Thank
Anthony Sprezzano?
I know, but I see a picture of somebody that has nothing to do with it.
Sprezzano,
Get
you're
rid of
here
that
for
smiley face.
trespassing municipal ordinance. That's
Yeah, now I'm okay.
City of Fort Lauderdale case.
More
Was there an
typing.
attorney appointed on this one already? Or was that under McHugh also? Did anybody give you an attorney, sir, so far?
Well, I thought the case was taken care of when I saw my probation judge.
Do you know whether anybody gave you an attorney?
Melinda.
Linda Blostein is with the Public Defender's Office. She's a mental health attorney.
Oh.
I used to previously
No, this
represent.
is not- Oh, yeah, yeah.
Yeah, so, and I don't think he was appointed counsel.
No.
And
Well,
it
wait,
shows that he was he was supposed to be ROR on this case.
Yeah, I was told I was going to go home on Saturday.
Sir, you've been released on your own recognizance. Thank you.
Wait a minute.
Thank you.
With the court.
Wait a minute. Are you sure? Like, the
He's
weird
still
thing I see in
being
Odyssey
held.
is that his bond was posted.
No, not Anthony Speranzo.
Anthony Speranza was ROR'd?
I have
On the-
this one right here if you want to
I'm
see.
just saying.
Why is he
that-
in jail?
Got it.
No, he's in custody because he's going to Broward Outreach.
Got it.
And I'm telling you, I'm showing that it doesn't
you,
show
sir.
that his palm was posted on this MO.
Okay, all right.
I'm just gonna show you what I'm gonna print out and just show you what I
Did
have.
we find Miranda Moorhart yet? Miranda Moorhart. We don't find her. We'll just have to reset her, all right? Reset her for Wednesday p.m. Here you go.
Is that it? We handled that already.
Take care
There
of
was
that.
a motion to release.
Two. Send it to the division. What did I do? Motion to release? No, we ROR'd him because he got a felony charge instead of that misdemeanor. I signed it. I remember.
Then that must be this guy here that I gave.
No. No.
No.
It's a whole separate case.
You're thinking you did the wrong. Check out.
Everything's-
Check out the name on that. Make sure we got the right name on it.
Yeah, for Anthony Speranzo.
Correct. Is that the right name at the top of that dispo?
Yes. Yeah.
Good, okay.
Do you also have an order for Cipriano?
No, I don't have.
I did Cipriano already. I know I did.
We did Cipriano, that was the one where the judge told.
I know, the question was the order?
I don't know what else I.
Don't care.
That's what I think maybe I did, I'm not sure. Yes, Cipriano was the gentleman who keeps coming in here with all the messages.
Yeah,
The question isn't whether it was the question is, was an order done?
I did an ROR for
You did an
Cipriano.
ROR, I'm thinking maybe it was, I did Sopranos.
May have gone in the wrong file, but I signed it.
And that's
So it
why I'm
looks
going to
like
ask once
signed
again,
two
do
now.
we have an order for Cipriano?
Yeah. Okay, thank you, everyone. Is that a wrap?
With a C.
Okay, no, I know, it's not you.
Yes. Thank you, everyone. That's a wrap. Am I correct?
I know it.
See
I'm
everyone
saying
back here tomorrow morning at 8:30 in the morning. We're out from 2:35. Thank you.